Today's Transportation Licensing Commission meeting, we've got a long agenda today, so please bear with us as we go through it all. If you'll please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you are not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Before today, we had last month's meeting minutes circulated. Has the Commission had an opportunity to review those minutes?
We have.
Is there a motion regarding approval?
So moved.
Second.
All those in favor?
Aye.
Motion passes. The first item on our agenda is under wrecker and towing services. We have a driver application for Mark Karn. Mr. Fields.
Mr. Karn has applied to be a wrecker driver. Mark Karn. Mr. Karn, are you present? He was not present at the February meeting.
Haven't heard anything.
So this is his second
He
absence.
was scheduled for February, and we rescheduled him for March.
Move to disapprove.
Second.
All those in favor?
Aye.
Motion passes. Next is we have an item under taxi cabs. We've been asked to consider a request of Checker Cab to allow Madison Rivergate Cab Company to provide dispatch services.
Yes. Checker Cab has asked that usually that their dispatch service, which is currently at their headquarter office, be done at 729 Calhoun Avenue, which is where American Music City Taxi is headquartered. That company would be doing the dispatching for Checker Cab. And there's an agenda item, and I can go ahead and announce it, and we won't have to do it under other business. There'll also be an announcement that there a request for transfer of the certificate of public convenience for a necessity for Nashville Taxi Ride doing business as Checker over to American Music City Taxi. So that announcement's now made, but they'd like to do this in advance. Is someone from Checker Cab here? We've got, both parties are here. This is a process, the Commission has allowed this in other cases.
And we need to approve it, or is this just where they have to give notice?
Just approval or disapproval, whichever you choose.
Any reason not to approve it, Mr. Fields? Make a motion to approve.
Second.
All those in favor?
Aye.
Motion passes. Next item, we have several company applications for other passenger vehicles for hire. Mr. Fields, do we need to take these up individually?
I don't believe so. All of them are in order, and you have all the material in front of you.
Do you have any concerns, Mr. Fields, with their applications? I would move to approve the applications for the other passenger vehicles for hire en banc that are listed here in our agenda.
Second.
All those in favor?
Aye.
Motion passes. We also have 3 company change requests that we've been asked to review.
The first one was, on your agenda is 808 Transportation to become an LLC, change of address, and to remove Toby Wright as a partner. Everything's in order. Oh, and I'd be happy to read them all together if you like. Paris Limousine has an address change. Zach Limo has an address change.
Any issues with any of the requests, Mr. Fields?
All of them are in order. The commission, basically, anytime there's a change to the face of the application, the commission's required to review it and either accept it or not. Pass it or deny it.
Move to accept the changes for the 3 different companies listed here in Bonk.
Second.
All those in favor?
Aye.
Motion passes. Next, we've got some complaints, consumer complaints that we've been asked to review. The first one is against Nashville Booting. Mr. Fields.
Ms. Kayla Mallard has filed a complaint against Nashville Booting. Ms. Mallard? Kayla Mallard. Ms. Mallard does not appear to be present. She was given notification of the meeting. Nashville Booting's representative.
Now, for these complaints, the complainant isn't required to be here. Is that correct?
They have to be prepared. Legal has advised me that the companies that have the complaint filed against have the right to ask questions and respond back. In this particular case, she did provide additional information that I suspect Nashville Booting would like to comment on.
So the old right of confrontation.
I'm told that's one of the things lawyers and courts require.
At least in the criminal courtroom.
So I think your option is to hear from them, to take action, take no action, or move it to the next month. We had no reason to believe she wasn't going to be here.
I've read the complaint, Mr. Fields. You said that the company might want to ask Ms. Mallard some questions. What did you see in the complaint?
What I believe they'll ask the question is the actual timing of the ticket that she presented as her ticket versus when the boot was actually placed.
Correct. The boot was placed on the vehicle at 11:55 p.m., 23:55 p.m. That was the time that the vehicle was immobilized for non-payment. There was no evidence of a proof of payment on the dash of the vehicle. She called for a boot removal. I responded as a technician out at 00:45, so at 45 minutes after midnight. She presented a ticket to me that she claimed that she had purchased that was displayed on her dash, but if you look at the picture of the ticket, now this is the ticket that she sent in, this ticket was actually purchased at 12:35, which was 10 minutes before we arrived to remove the boot from her vehicle. So she purchased this ticket from the pay machine after she found out her vehicle was immobilized as an attempt to not have to pay the booting fee for non-payment. It says 4:35 a.m. That's expiration. If you look right below that, the purchase date and time is 12:35 a.m.
You don't have anything that could show us when she called in requesting the boot be removed, do you?
No, but that was the time that we removed it, was 10 minutes after that ticket was purchased. Her vehicle was purchased or was booted a couple hours before that. Or, yeah, an hour before that. So
Does the ticket show a time? I'm trying to see.
ticket shows the time it was purchased.
I'm talking about the notification.
Right. If you look up there, it says time of immobilization in the upper right-hand corner. It says 23:55 on 2/2 of 2018. And then 3 lines down is the removal time of 00:45 on 2/3 of 18, which is, and then if you look on the other page that shows the picture of the ticket she sent in, that ticket was purchased 10 minutes prior to the removal time. The boot had been placed on there prior to midnight. This ticket was purchased at 12:35.
Now, are these pay machines, is the time
The time is accurate.
accurate?
Yes, sir. It's very common in these situations for people to purchase tickets from the machine after they're booted or get tickets from somebody else who's already paid, and they try to present that, they try to present that ticket to us, and state that they paid for it.
The ticket that I'm looking at here that shows the expiration date and time of 04/35
Correct.
seems to be on top of, was copied on top of something else.
Do you not have the other one that shows that by itself without the?
No, mine's on top of it, but it shows a $160 payment. Is that what they
No,
paid
it's
to
a
get?
$60 payment.
$60 payment.
Correct.
Okay. So it's $50 to get the boot off and then $10
And then you pay the
more?
$10 for the parking, correct.
Okay.
I think he's taken on top of this.
Yeah,
Maybe
that's what I've got
23,
right here.
yeah.
I have a clean copy of it if you like.
That's all right. I was just curious. Yeah, see, I've got mine. Mr. Fields, what, I'm trying to remember our choices of action here. Obviously, we can find the complaint, or do we have to make a finding of there's no action to be taken?
I think if you take no action, and again, I always look at legal, but if you take no action, there's no action. It just means that she filed a complaint, commission heard it, you chose not to take any action.
Do we have to make a finding, though?
I don't think they have to do anything. You
Okay.
just, if there's no motion, you move on to the next agenda item, and it sits there, I think, and it basically goes away with the end of this meeting.
But we don't want the complaint to,
Linger.
You could dismiss the complaint without, I guess they could dismiss without a
I
finding.
wonder,
If they,
because we always asked
yeah.
them.
Again, without her being present to prosecute, it's incumbent upon her to be present for the prosecution. If we required them to be here, we can't require her to be here, but
Well, I also think, though, I mean, she does have a right of an appeal, and I think it would be efficient if we did have a basis for our ruling and not take action. So, the booting company knows why we ruled, so she knows why we ruled, and then the parties can make a decision from there.
So you're recommending that we actually make a finding and
Yes.
rule on the complaint?
Yes, based on what we've seen here, it seems that the documentary evidence shows that she purchased a ticket after the boot was on her tire.
You ever had any problems with Miss Mallard before, or any complaints from her?
Not that we're aware of. This is the first time that if she's been booted prior to this, it would, we didn't research that, but, this is the first time that she's ever, filed a complaint.
Well, I'll throw this out there. I'll make a motion to dismiss the complaint because the evidence before us today is that Miss Mallard purchased the ticket that she presented to the company after the boot had already been placed on there, and that this was a proper booting, and the complaint should be dismissed.
Second that.
All those in favor?
Aye.
Motion passes.
Thank you, sir.
I tried.
Next, we have a complaint against Southern Comfort Carriages. It's a number of complaints, it appears. The first is from Tina Doherty. Are these related, or are they three separate complaints?
they are, let me double check it.
Your Honor, if I might speak, Ed Howell, Nashville Bar, back again on, my Thursday is filled for the last couple of months. They are related. All of the complainants are drivers for competitor, Mr. Johnny Smith's group, and we know what happened with that. So, yeah, they're all definitely related. I assume they're here.
Two out of the three are present. Ms. Doherty is present. Ms. Warren Zuniga is present. Ms. Mulgrew called this morning. She had an emergency at her office involving water pipes breaking, and since she's in charge of the office, she's attending to water all over her office. And she asked to move the hearing. I advised her that once it's on the agenda, the commission takes it up. It's the commission's decision on how to deal with that if she's not present.
Well, we're here, Your Honor, with several of the drivers for my client. We didn't try to pack the courtroom necessarily, but they're here.
All right.
And whatever the commission decides to do, we can go forward or we can wait.
How are they all connected?
Well,
Real briefly, though.
I'm going to try to be brief. It's kind of hard, but as the commission understands, Mr. Smith is no longer allowed to be down with his company downtown. So it appears that they've taken it to heart because he was stopped from being down here. Originally, the whole company was to be stopped for 6 months, suspended for 6 months. Now they have decided. He has decided, or somebody in his stead has decided, and I assume it's Miss Kama Warren Zuniga, has decided that they need to set up one of the other carriage companies to have some kind of action against them. And that's what we say has happened. They have taken pictures. I don't know if y'all have seen the pictures or not, but they're basically videos and small snippets when carriages are trying to get into a parking place, that kind of thing. And I think one of them is one of the passengers standing up in a carriage for just momentarily. And another one is, several of them are where the carriages are in line trying to get into the parking area. Of course, we have some pictures of the other company doing that too, but that happens down there. It's just, and basically it all hies back to several years ago when all this started with regard to Mr. Smith and his actions down there in trying to control things when he couldn't.
Well, why don't we do this? Why don't we hear from the complainants,
That'll be fine.
and then you'll certainly have an opportunity to respond.
Ask them questions if I
Yes.
can for this. Thank you very much.
Ms. Warren? Hello.
Good afternoon. Brian Kroll here on behalf of Ms. Warren. She's hired me to help facilitate presenting this complaint. If it pleases the commission, I've gone ahead and typed up a copy of the handwritten complaint with citations to the Metro ordinances.
This is Ms. Warren.
To correct one thing immediately, there's only one person who's a driver for Sugar Creek Carriage at the time of that these complaints were lodged, and that's Ms. Warren.
Ms. Warren?
This has nothing to do with Sugar Creek. This is her own individual complaint. Ms. Warren, would you introduce yourself to the commission?
Yes, my name is Kama Warren, and I am a carriage operator in downtown Nashville. I have been an operator for 20-plus years all over the United States, to include California, Texas, and now Nashville. I also have been in the equine industry for 40 years, to include owning, training, lessons, and showing. And I also am currently a professional horse owner. When this complaint was filed, it was not filed as Sugar Creek. It was filed as Kama Warren. And it was done because of the concerns for safety to our people in Nashville and our carriage industry. It was not done as Sugar Creek Carriages.
Has there been any complaints from business owners?
Actually, yes, there has. Regarding the diaper and excrement issue, which one complaint was, I have been counseled and spoke to by a couple of the business owners on 2nd Street regarding the carriages dropping excrement and leaving the carriage stand a mess. One of the businesses paid $40,000 to have their windows open. But with the failure of the diapers and them not being placed on the horses and harnessed correctly, it's leaving excrement on the streets, leaving a smell. They're not able to use their windows to open for their diners and everything else.
What business is that?
Distillery. And I've also been talked to regarding the Jack Daniels store, which is next door, and they complain about it continuously as well. And we do have some pictures that are coming up for this, of the diaper issue.
So that's a violation.
That is a violation, and it,
1254-200.
1254-200, A number 6. This horse here has the diaper attached, but see with the flap, not attached into the diaper. Also the same thing with this horse here. There's no way, if the horse was to relieve itself, for the excrement to end up into the diaper. It'll end up on the ground.
Back to the other ordinance.
All right, and I see you've got a few other violations that you're complaining about.
Yes. We can go to the top where the red rear lights. There are no red rear lights working on this carriage. And according to the ordinances, the driver shall at all times observe and obey all traffic laws and regulations. With traffic laws and regulations, even on a vehicle, you have to have the red rear lights. And these carriages had been out there. That one's only has one. And these carriages have gone out numerous times. For weeks on end, we watched this happen. And they were not repaired or replaced.
Did you bring it to their attention when you noticed it?
We are not allowed to speak with them.
All right, you can go on to your next violation.
Let's see. Standing the carriages in areas where we are not allowed to stand them in. This is parking in a no parking area. It is posted on the sign, no parking. We've also been asked as drivers numerous times by Metro, and we are governed under Metro Police Department, not to park there. And it's also a Metro vehicle code that we are not allowed to do that. We're not allowed to park within 20 feet of a crosswalk or a intersection, as well as it is illegal and against the law to park in a crosswalk.
How deep was the line to the stand?
The carriage stand allows 4 carriages. At those times, there was between 5 and 6 carriages sitting there.
And when that happens, is the carriage just supposed to keep going around the block?
Yes, we are supposed to circle. This here is, they sat for over 2 minutes blocking the street. This also carriage has no red rear lights on top of it, being an extreme safety hazard, not only to the horse, but to the driver and the industry, because what happens if somebody doesn't see it because it's not lit and it is rear-ended?
So what I'm looking at there, the one that's in the street, but then the one to the left where someone just stepped in there, I see that red light. Is that how the light looks when it's lit up? On the
They
back
should
of
have
the
some form of a red light, like a tail light, a steady tail light on your vehicle, some form of a red rear light. It can be a strip light, or it could be just your red rears, like you would have on a trailer. Any form of a red rear light. Some of the carriages even have bicycle lights.
My question is, that's an example of,
That can be an example, yes. And they sit there for well over 2 minutes. I think I got about a minute, 2 minutes of video that it sits there. We already have enough congestion on 2nd Street, let alone the hazard of that.
All right,
The standing in carriages. This carriage is obviously on a tour. Our ordinance states that before you even leave the stand, you will advise your passengers to remain seated at all times unless they are boarding or unboarding the carriages. Per se, this carriage gets rear-ended, these people are standing in the carriages. What's going to happen? He's not protecting his passengers.
Is that at a stoplight?
I don't know exactly where that is because I do not remember. In the car, it's at an intersection, and I can't quite remember. I've got so much film footage and pictures that they're all moving into one. But it's still an extreme, and especially because the driver is facing them and not paying attention to what's going on with the horse.
The person taking the picture, are they driving
They're-
while they're taking this photo?
I, at that time, we ride 2 drivers on our box, and I happen to be the second driver on the box.
Do you think it's possible he's turning around and tell them to sit down?
They had been going that way for quite some time. It had been quite some time we'd been following.
There's just one photo of this?
I have so many, but with changing of phones and stuff, I don't have them with me. But yes, there's probably quite a few videos of this happening.
But right now, we just have that.
I just have that one with me. It's still an extreme safety hazard. And before we step off, and I know I make sure when my passengers board my carriage, I request that they stay seated at all times. Unless they need to get up and move for some reason, please let me know so I can pull over and come to a full stop.
All right.
I think that
That's all of them.
If there's any questions from the commission, we're ready to, I guess
Now-
we'll wait until they come up.
Now, I'm sorry, I've forgotten your name.
Bryant Kroll.
Mr. Kroll, you said that Tina Doherty and Jennifer Mulgrew are not drivers?
Which one was, this Doherty is not a
No, she's definitely not a driver. We don't even know. Mulgrew's definitely not a driver downtown.
at the time of the complaint that Tina Doherty made, she was not a driver for Sugar Creek. Since after that time, I guess she is.
She's become a driver
She's become
since she's come to us and requested to become a driver.
Did she work for Sugar Creek in any capacity during that time?
Who? When
Tina
Tina?
Doherty?
No, she did not. She did not work for Sugar Creek Carriages.
And Ms. Mulgrew still doesn't work for Sugar Creek? Okay.
Ms. Mulgrew does not work for Sugar Creek Carriages at all.
All right. Well, thank you, Ms. Warren.
You're welcome.
Might I ask a couple of questions of this lady?
Yes.
Is that satisfactory?
Sure.
Ma'am, you work for Sugar Creek, right?
Yeah, I am a carriage operator, yes, for Sugar Creek Carriages.
And back in 2017, 15 September,
This has nothing to do with Sugar Creek, and I'm not going to answer questions regarding Sugar Creek Carriages. If it's directed at me personally, yes. Sugar Creek Carriages is not involved in this matter.
You're the manager.
Well, Ms. Warren, that's really up to us as the commission to decide if you should answer the question or not, so.
Okay, if the commission deems it, yes, but it has nothing to do with Sugar Creek Carriages.
did you,
Go ahead.
thank you. Did you sign a declaration back on the 15th of September in support of September 15th of 2017 in support of Johnny Smith and his efforts to not be removed from working downtown?
Yes.
Is that it?
I'm sorry, can you repeat that question?
The question, is that it?
No, well,
Okay. Excuse me. Did you sign a declaration back in September of 2017 in support of Mr. Johnny Smith with the opposition carriage company, the carriage company she works for, that she now, my understanding, she now runs, in support of him not being removed from practice down here. And may I? Thank you. And that was, I'm not sure that the folks on the commission have seen this, but I have a copy. I don't have more than one. If we want to see it, basically what she says is she denies everything with regard to what caused Mr. Smith to be removed. She denies everything, and we know that the commission found that they were true. So that's where we start with this lady. Now, with regard to the other lady that was supposed to be, sorry, I apologize, I had it here and then I moved it. Who is it that is now working for Sugar Creek that
Ms. Doherty?
Ms. Doherty? She is now working for Sugar Creek, is that right?
Yes.
Now this other lady, what's her name?
Ms. Mulgrew.
Ms. Mulgrew? What connection does she have with Sugar Creek?
None that I know of.
You know her? Okay. Does, as far as you know, she doesn't know anybody in the
She's not related to
company.
anybody with
I
our
didn't say,
company.
know anybody. Does
No.
she, is she, okay, that's fine. Now, these problems that you're having, why did you start taking pictures?
Why? Because these are safety concerns. I love my job. Any accidents out there is going to terminate the industry in Nashville.
Okay. And so running without lights is really dangerous, is that right?
Yes, it is.
And y'all don't ever do that, do you?
We have preventative measures if our lights are to go out. I have rear bicycle lights that flash red.
Is that your carriage?
No, that's not my carriage.
It's not.
No, that's not my carriage.
Whose is it?
I don't know.
Is it not one of your company's carriages?
I don't know.
Oh, so it could be Sugar.
I don't know whose
It could be
carriage
Sugar
that
Creek
is.
carriage, right? But you have safety requirements that
We
you
have.
can put them back. May I?
You may. I don't know how relevant it is.
Well, I understand that. I understand it, but it's back on the wall. By the way, that was presented to, I believe, Mr. Fields. Have you seen that picture? That's something that one of your, I think one of your inspectors might have.
It's,
Okay.
we do get a lot of pictures.
Do you remember that one? Is that a Sugar Creek carriage?
All right.
Again, from this particular angle, it would be a challenge to do it.
Okay. That's why I needed Mr. Bowling here, and he's not here. Sorry. Now, and please, you've got to understand, I'm not trying to say that it's just because this is a put-up job that it's okay for these people to do something they shouldn't do. But we deny that any of this stuff is going on. I mean, we can explain the pictures. Obviously, they went to a lot of work to get these pictures in, but we deny that any of these safety hazards are going on. And we've got people here to testify to that.
Well, I will.
I have a question.
Go ahead.
So I think in one of the pictures, we saw the sign that said Southern Comfort.
Right.
And we actually saw the person standing.
Right. And
So-
there's no question, there's a picture there of somebody standing. Now, what the reason she was standing and what was going on at that particular time, I don't think we can figure that out from the picture. Whoops, excuse me. What we have is somebody who has filed this for obvious reasons now. You see, that's what it is. And it's her testimony that somebody was standing up while it was moving. You've asked, was she at a stop sign? What was it? Obviously, it wasn't moving at the time. So, I mean, there's a lot. This is not the first time I've been here for any of these folks. And I've represented everybody but Johnny, thank goodness, Smith. But in this particular case, it's just, I mean, they're just making things up or taking things completely out of context. Let's put it that way. think
Mr. Highland, I think that whether or not Ms. Warren or anyone else at Sugar Creek's violated an ordinance is not before us today. I mean, it has no bearing on whether or not the complaint against Southern Comfort matters or not. And I think also the fact that there is so much animosity between the carriage companies that you're looking out for any type of violation report also doesn't really matter from our perspective of is there been a violation of the ordinances or not.
that's what I understand that. There's no question
In
about
fact,
that.
you've probably made our inspectors' jobs much easier because you're self-policing each other and reporting violations. Now, we certainly understand that there are probably some motives behind the reporting, but if the evidence shows there's been a violation, there's been a violation.
That's what I attempted to say just about 2 minutes ago. Your Honor, I'm not trying to say that if there was a violation, that just because they caught it is something that shows that they're doing something they shouldn't be doing. But considering the circumstances, it appears to be in the interest of these folks that are taking the pictures to say things happened that didn't happen. For instance, we have one coming up about cantering a horse. Coming up, that's the next one. One of these folks is talking about cantering a horse up the hill. We'll talk about that in a little while. You can't tell if the horse is being cantered. No way you can. There's a moving picture on that one. And so it's a matter of interpretation of the photograph. You have to look at it and see, is there another reason why these carriages should be there? Is there another reason why this person is standing up? Is the carriage moving? And you've got to make that decision. I mean, you're the commission that has to do that. And if my client says that it really didn't happen that way, which they will, then, in fact, most of these, it's going to be kind of hard for anybody to say exactly who it was because you don't have a good picture of the driver.
So what's the response on the horse excrement allegation?
Nobody has told us, anytime we have a bag goes on the back of the horse, anytime we have one that way, it needs to be changed, needs to be fixed. That happens to every one of the carriage companies, every one of them, including this lady's. And if there's something wrong with them, they are fixed. Now, that's something that you can pretty well guarantee because the only people, the proof's going to show, the only people that have a real problem with that, and Lord, I hope there's nobody in here that's a Metro police officer, but their police bags on the back of their horses have serious problems because sometimes they go a little bit faster and sometimes they have problems with it too. And we know of many occasions where the problem with the excrement on the road is the problem of the police officers. I mean, they can't get off and pick up everything a lot of times. They got something else they got to do, but their bags fill up. So it happens. But in this particular case, there's no showing that this happened, that this caused this, in this particular case, it wasn't immediately corrected, or that at any point the excrement came out of the bag or out of the horse onto the street. There's no pictures of.
Yeah, if I could just say one thing about that. Picture of the bag that she said was not attached. The picture you saw is the picture of every horse carriage in Nashville, except I designed a flap that goes right under the tail. My flap wasn't connected. But to say there's something wrong, the bag, that's all the other companies have is the bag. So I'm in line with all the companies with the bag. I have a flap design that was not attached on that particular picture. That's all I say about the bag. This was a driver for the people standing up. He was turned around at a red light, telling them to sit down. If you think for a little bit, if you notice, everything's a moving picture. Why wasn't that one a moving picture? To dispute what he was doing. But it looks better to have a still picture to say they're standing up as he drives. Incidentally, just one other point I'll make. They have 8 to 10 people following us around with cameras. We don't do that. Although, because they have harassed Russell so much, he carries a camera for his own protection. But he has video. We're not prepared with it today of them doing everything they're accusing us of. He has it where they're actually rolling down the road with people standing up. But I just got up to say that so maybe y'all could read between the lines and see what really is going on.
And we do have some of Russell's films, but as you said, just because they do it doesn't mean that we can. We don't do it. That person that was standing up, obviously, if he was turning around and telling them to sit down, that's all he could do, except maybe toss her off the carriage. And if he was stopped for a stoplight, then that means that the picture they took was not an image that showed that they were doing something they shouldn't do. It was a picture that showed somebody standing up in the process of sitting down, if we're to believe this gentleman. And Paul he's here. He's never had a problem as far as I know. He's always run a good operation. And we have other people here that will testify to the same thing that he's testifying to, same things. People that will deny that this stuff went on.
May I speak?
I don't have any problem with somebody else saying something if they think they have something to add.
I'm the driver of the carriage where the 3 ladies were standing in the back and someone in the front seat was taking their picture. They were all together. They had come together. They had met here as a neutral place to get on a carriage and ride around and talk and be free of anybody else in their group, I suppose. But that particular location, we were at a stop sign. And I don't know what intersection that was either. But at any rate, I turned around to address the fact that they were standing. And I have the reins in my hand, and I know I'm a horse. That horse I've been driving for a long time, and I know when they move to turn around and look the other way. But there was a horse behind me and a carriage. So if I was going to get rear-ended, somebody was going to have to hit the carriage in front of me, I think. But at any rate, they were standing up, having a good time, and had a picture, and then they sat down. Not everybody is that way, and every driver has to contend with the fact that there are people in various states of sobriety on their carriage, acting however they desire. And sometimes you have to threaten them with getting off the carriage and ending the ride. That was not necessary here. Any questions for me?
What's your name?
Philip Hunt. That was carriage 81.
You're telling us absolutely you were stopped and you were turning around to tell these people to sit back down?
Yes, sir. I do not drive looking backwards.
How'd you come to aware that they were sitting up on the back part of the carriage? Or
We were at a stoplight. I have a dog with me. The dog's on the front seat, and he notifies me of things going on around the carriage. And he was paying attention back there, and they were talking, so I turned around. We were not near 2nd Avenue or Broadway where there's lots of noise, so I was able to hear more what was going on back behind me.
And I thought I did see in that picture the 3 ladies sitting up on the back of the carriage, and it looked like someone down lower. Was that the person taking the picture you're talking about?
Yes. I don't know, were they sitting on the carriage or standing up in the floor?
I'm hearing standing, but to me,
They
I
were
believe they were
standing.
standing.
They were standing.
so they're standing, okay.
Yes. There you go.
They're standing.
That's standing?
It looks
And that
like,
does not look
looks
like a
kind of
person
like sitting.
taking a
Yeah, I
picture,
kinda
they're just
thought
turning
Their
around.
ears were down on the back part of the carriage, but,
Right.
all right, so that's standing.
So they're posing for a shot because they're all friends and
And
they're out
between the-
having a good time.
between the
We're at a
middle one-
stop line, we're just stopped.
Mr. Hunt, one second. Between the lady in the middle and the one on the right, there looks like a face
There
turned
is a
around
face.
smiling.
Yes. It's another lady's face.
And that's the picture taker?
Yes.
All right. And that's you with the hat on
Yes, sir.
and the bandana?
Yep.
Where's the dog?
You can't see the dog because the shoulder of the lady above the head.
All right.
That's what the dog would be.
And then I see a white car kind of making a turn. It looks to me like they're making a turn
Well-
in front of your carriage.
Now that I look, do you see the right shoulder of the blonde in the middle?
Yeah.
Do you see, but right to the right of her head, there's white?
Yep.
That's my dog.
Okay.
And you'll note that if that car is turning from that intersection, it has to be stopped because the carriage has to be stopped because the car is turning, taking the advantage of the green light.
That's why I was pointing out that white car.
Thank you.
but- Is that the Renaissance Center up the road?
No, that's Commerce Hill going up towards 4th Street. That's at 3rd Street.
Across from Baker Donald's.
I believe you're right.
That's right by Demos.
Demos is to the right there on the opposite.
And the Wild Beaver Saloon is right there on the right.
Yeah.
Okay.
All right, regarding the, I think we've heard enough about the excrement and the standing, but regarding the lack of lights on the rear of the carriages, what's the response there?
Your Honor, I'm not real sure that I can explain it. I say, Your Honor, I apologize. I'm used to that. Why do I say Commissioner? You haven't, never mind. I would suspect that the reason that light does not show on is, and I think she spoke to that, it can be one or, you can have more, just one light back there, I think. I'm not sure.
It has to be like a vehicle, 2 red rear lights to the rear.
I don't know that. Okay.
That's what the ordinance says.
So my understanding is they have to be turned on manually. And this was right at the start of a shift there. And I would suspect that the switch had not been turned on, but was turned on because if Mr. Bowling or someone else, I mean, that's where this picture came from. It's one of the other carriage companies. A picture was taken by Mr. Bowling. And it shows the lights out on their carriages. But he says it happens a lot of times, and I'm saying we've heard a lot of stuff about excrement in front of somebody complaining about this excrement in front of places. That was hearsay, but I'll just tell you, this is something that happens a lot. It's turned on immediately. Somebody takes, like you asked a while ago, did you bring it to their attention? This lady said that she was told she couldn't talk to them. Well, you didn't tell her that. This commission did not tell her that. I don't know who told her that.
Excuse me, yes, the commission did tell us that. We are not to have any communication with the competitors.
I haven't found that in the minutes. I don't know that. But they don't have to tell the commission, tell the people. They can tell Mr. Bowling, or they can tell Mr. Morris if he's down there, or they can tell Mr. Fields if he's down there. Mr. Fields, at that point, they say, hey, why don't you go get your light turned on? In this particular case, we believe the light was on immediately after this happened because it's sometimes if you're in a trip with a carriage and you start up and it gets dark enough to have a light on, you have to get off and do it, and they just hadn't done it. I'm not sure about this one, if there was folks on this carriage or not.
If you don't mind. Ms. Morrison, could you stand up a second, please? What's the deal with no lights on some of these carriages and your carriage sitting in the middle of the street there on 2nd Avenue? And who's the driver?
The one that had no lights, well, we have our switches are right by our legs. Quite often you turn to speak to someone like they were speaking, you hit that switch and the taillights go out.
Do you have any explanation for the pictures we've seen here today about why the lights were out?
Yeah, that's,
Specifically to those those days and that times those carriages?
I suggest it was bumped, the light switch was bumped, and they went out, but as soon as someone hollers, hey, your lights, you go down the street and you click them on.
What about the carriage sitting in the middle of Second Avenue or in the lane?
Well, I noticed, I was watching that video, I think there was 3 cars that passed, but they pulled up beside another carriage to get instructions on where to go pick up a ride. They had a ride at a hotel. The carriage that was up front was going to stay and try to get a ride on the street, and they were sending that carriage to pick up the ride.
You're sure about that?
Yes.
Who was it?
Kenny?
We have him here. Kenny?
You don't know. All right. Introduce yourself and just tell us what's going on.
My name is
Were you the
Kenny.
go ahead.
My name is Kenny Hale.
All right, Mr. Hale, were you the driver of that carriage that we saw?
I was not the driver of the carriage. I was the driver at the front of the spot.
Who was talking to the other one?
I was talking to the other driver.
Are you both with the same company?
Yes. We're both with Southern Comfort Carriage.
Who's the driver of the one that was sitting in Second Avenue?
Jessie Monville.
Is he here?
She's not here.
She's not here? Why not?
Because she goes to school on Thursdays, but she didn't go to school today. But the reason she's not here today is because she had a doctor's appointment to have an ultrasound.
Pregnant.
No, she's not pregnant.
So what do you remember happening? Do you remember that incident that we just saw?
Yes, sir, I do remember that incident.
Why do you remember it?
Because where they're talking about illegally parked, she had just pulled into the carriage stand and she was pulling off to circle the block. And I stopped her and I said, hey, just had a call in, we got a pickup, and I'm giving her instructions on where to go, where the pickup is, how much it is, and everything else. She might have been blocking the left lane of traffic, but the right lane was free, and everyone does that, even if...
Well, it might have been blocking the left lane. She was blocking the left lane of traffic.
Yeah, she was blocking the
and her
left
lights
lane.
were out.
I don't know if that was...
I couldn't tell if her lights were
Her lights were out.
The lights, don't you
Yes,
make a
and
point?
2 of those carriages operated for well over 3
I
weeks
just want to
like
make sure
that.
the lights were out, right? You mentioned to her lights were out when she pulled off?
I couldn't tell if her lights were on or off. Her red lights are up underneath. Since all this has come to our light, we have therefore replaced all the lights on the carriage.
Every one of ours.
Every one of our carriages have new
Something I
lights.
needed to hear today. Thank
As
you.
soon as we got this report,
Yeah?
I just replaced all the lights, put new triangles that have LED lights all in it. I thought, my gosh, we'll just take care of all this on every carriage.
Where's the switch now?
The switches are in the same places.
And the other thing, it could not just be the switch. The other thing, the other companies do it too. We're required to have batteries on our carriages.
You have to
And
change.
you have to change the battery. If you're in the middle of a ride and your battery goes dead, you can't just stop in the middle of a ride and change your battery. When you get back to the carriage stand, we have someone that's on the sidewalk that will watch our horse while we change out the battery. Some of our batteries are where we can change them out.
How much, Ms. Morrison, how much did it cost you to change all the lights in the back of the vehicle for your carriage?
Well, it was about $300 for the LED things, and I guess I haven't totaled it up, probably about $50 each carriage.
Yeah, how many
Actually, more than that, they're LED lights.
How many carriages?
We did 5.
So about $1,000
Yes.
total.
And I will say that they say they're not allowed to say that. That's fine. Their boss, owner, whatever, has even told me and everybody, we're not allowed to say nothing to them. But I will be the first to tell you, if I see something that is a safety violation, I don't care what Mr. Smith says to me or what have you, I have went to several of his drivers or people on the sidewalk and said, hey, check the back left rear of such and such carriage. And they just act like they don't hear me. Within 5-10 minutes later, they're checking that carriage, and that carriage has left the street because it was unsafe.
That's safety, a wheel falling off or something, but, and we tell them. In other words, they wouldn't tell us. They'll take a picture and turn it in and hopefully get some kind of trouble. But if we see a safety, we go tell them. They've called me and said, hey, his wheel's about to fall off. Should I say something? I say, go tell him. Let them know.
Heard enough of what you do. Thank you.
How about anything else? Any other, we might have other drivers here.
I think we've heard enough.
I'd like a chance to respond to some.
All right. You may.
We could pull back up the picture of carriage and traffic, or the video. As you can see, the lights are not on that, but
The decorative lighting is on.
What does
So
that
the
mean?
batteries are still working.
now after you made this complaint, let me back up just a little bit here. How many times did you see people with their lights off?
This has gone on with the red rear light issue at this point for well over 3 weeks, since they came back from Opryland.
Pause the video, please.
The decorative lighting is on the carriage.
There is 2 red lights, one right there, one right there.
Those are actually white, not.
Those are white.
In addition, we
Those are
have
white lights.
extra lights that are not required. All those extra lights are so cars and people can see us.
That's just decorative extra lighting that's not required.
However, the required red lights are clearly not on.
Those are white lights.
All
Those
right.
are not
Do you
red.
have another point you would?
Yes, we do. Included in the handwritten complaint are a series of dates and times for where this was happening.
Yeah,
And
I mean, and he's saying start a shift. How can start a shift? This is a Saturday. I think it was like at almost 7 o'clock at night. That's not start a shift on a Saturday night. Some of the light issues are at 9:30 at night. That's not start of shift. 7:49 at night is not start a shift where they would turn on their lights. It's, at that point, in January, it would have been dark. I roll out of my barn if it's dark or sunset with my lights on. I have a check sheet that I have to do on my carriage. I have to physically check, make sure all my lights are working, my extra safety lights are working, and everything else, make sure my batteries are charged, make sure all my bulbs are working. If not, my carriage doesn't go out. It gets shut down until it's repaired.
All right. Well, thank you.
Now, after you made this complaint, you'd observed this for, you stated, weeks. After you made the complaint, which they've acknowledged receiving, did you notice any changes to these carriages that didn't have lights on?
They left for about a week, week and a half, and then after the complaint was made, and then the carriages came out, and the lights were repaired. Then they went down again for another week, and the carriages came back out, and they were all completely repaired after the complaint was filed.
All right. Well, I think we've heard enough that we can deliberate and with this complaint from you, Ms. Warren. Thank you.
May I say one more thing, please?
I think we've got enough. Thank you. Yeah, I mean, it seems to me, I don't get to make a motion, but it does seem that the evidence regarding the horse excrement and the standing of the passengers was insufficient to show a violation. And certainly we have the explanation from eyewitnesses. At the time, the driver of the carriage who was driving, the passengers in the photo showing them standing, and we also have testimony from the manager of Sugar Creek, Southern Comfort, who has explained the diaper bag that he uses for his horses, and also the photo didn't really show anything. It was just the horse appearing not to have a diaper.
Well, it did have a bag, but
Right.
the question was whether it was in position to catch the feces.
Right.
But I would concur. I think on those two, there's insufficient proof that that horse in that picture was violating any ordinance. And I think the gentleman who spoke up regarding, is it Mr. Hunt, right?
Yes.
Mr. Hunt explained the situation about the conduct of the passengers who were seen standing, and I'm pretty sure that picture there that we saw showed a car turning in front of the carriage, so it had to be stopped. And I'll have to take Mr. Hunt's word that he was doing what we would expect him to do to get his passengers back to a seated position.
Then that leaves us with the blocking of the left lane of traffic by the driver. I've forgotten Jesse's last name.
Mondale.
Mondale? Monville, Miss Monville. And the testimony was that she was receiving instruction from another Southern Comfort driver to pick up in a hotel. It also appeared that the lights were out in the back of her carriage at the time. And also the testimony was that Miss Monville was stopped for approximately 2 minutes.
And there was testimony that they took remedial action to correct the light in the back of the carriages.
Mr. Fields, can you remind us as commissioners what options we have if we find there's a violation?
If you find a violation, you can, obviously you can reprimand, you can place the driver and/or the company on probation, you could suspend the company, you can revoke the permits. You can take no action.
And it can be either the driver and the company, or both the driver and the company.
You would have to actually charge, I think would have to actually bring the driver in front of the commission for action. I think the company this was described to the commission as a company-wide issue through this complaint, I think. I'm not going to speak for the folks filing the complaint, but that would be, it was not filed against the driver, but against the company.
It does say against Southern Comfort Carriage Company.
Correct.
What's Southern Comfort's, yeah, their violation record over the last year or so?
I don't think we've had them in front of the commission for anything. I'd have to go back and check the records again, but again, if we're talking about complaints, it's not unusual for the commission staff to get complaints on not every company, but on many of the companies we regulate, whether it's horse and carriages, or slow-moving vehicles, or pedicabs, taxi cabs, and so forth. Many times there are issues that are correctable when brought to the attention of the company, and that ends the complaint. Sometimes we get complaints that aren't sustainable, and we don't bring them to the commission because there's no evidence that would get it to the commission. Other than the companies against one another in the last couple of years have been relatively quiet in terms of public complaints, other than, there have been a few. We had an issue last fall, but we've had more of the companies having problems with each other.
Well, I see it as a single incident regarding the vehicle in a lane of traffic, or a carriage in the lane of traffic that was being operated by Jessie Monville, and from what I can tell, she chose to sit there in that left lane of 2nd Avenue while getting instructions, about to go pick up another ride. have a hard time seeing that as a Southern Comfort company-wide problem. But the lights appear to have been a company-wide problem, especially since I heard testimony from Mr. Morrison that they brought them all in and changed them at a significant expense to him. And I share that just to kind of give my own thoughts of delineating or compartmentalizing these two remaining complaints.
So Billy, I assume once a complaint is filed, the company that it is filed regarding, that it is filed against, you all send that information to them? So it sounds like as soon as they got the complaints, they did, as far as the lights go, take action to correct. And then do you have an inspector that goes out?
We have
and
inspection on the
checks?
street every night, and I can assure you, if they see lights out, they're going to bring it to the attention of the companies. That's any, whether it's a taxi cab light out, a limo light out, or whatever it is, certainly on carriages, we want to make sure they're well lighted.
And so they bring it to the attention of the company, do they then bring it to?
Oh, no,
their
they'd go to the
attention?
driver immediately and say, hey, we've got an issue. I'm going to hear some of them not. Again, some things are incidental issues that happen on the streets, and we want, compliance is our goal. If it's a continual problem, then we certainly going to take a different approach than if there is an issue for an evening. In this particular case, I don't recall or have any evidence that it was brought to us. Still, the complaint came forward.
So if we go with the one with the obstructing traffic, because in my mind, that was fairly obvious that she chose to sit there as well. But I guess I'm a little confused about, since it wasn't filed against her, could you think?
Well, if we found that it was a company-wide practice of violating that ordinance, then it would. But what I noticed was it's one incident on, I think it's January 28, 2018.
Right, we cannot take adverse action against Ms. Monville without deferring and asking her to appear and answer the
Well, or
allegation.
until a complaint is filed against her, right?
Right. Well, we
Unless
could
can find it.
observe
Yeah.
ourselves that
That's true.
there was a violation.
Well, in the past, haven't we first took a vote on whether there was a violation and then took a vote on what kind of sanctions, if any, were appropriate?
Yes, we've
Right.
certainly done it that way. I mean, we've done it both ways, but we've certainly found a violation and then decided what the sanction was.
Well, I'll share my thoughts about things at this point. I think there was a company issue regarding the lights on the back of the carriages, but I'm very impressed that Mr. Morrison took action right away. But I would like it to be on the record, though, that there was a problem and that this commission takes it serious about the lights being active and working on the back of the carriages for the safety of traffic and of the public downtown. So my thought would be that we find that there was a failure to keep red lights on the back of the carriages, but that there's no need for sanctions at this time. And I'm just throwing that out for discussion.
I would agree with that.
I agree also. So I guess, do we need to make a motion?
Yes, we need to make a motion.
All right. Does anybody else want to make one today?
It's your idea. You're on a roll.
Okay. I'll make a motion. We find that there was a violation of, help me out here, a violation of
1254-200.
200 or 260? I think it's a violation of 12-54-260 regarding carriages shall be equipped with lights that comply with all applicable state laws. And I'll go ahead and I would make as part of that motion that no sanctions are required at this time because of remedial action taken by Southern Comfort Carriages.
A second.
All those in favor?
Aye.
Motion passes. That just leaves us with the issue of the blocking the left lane by Ms. Monville.
And she's not here, right?
She's not here.
So from what I can tell, it's our choices as to whether either to dismiss that complaint on that, unless other folks feel like it's a company problem, but either we can find it's a company problem, or we can dismiss the complaint, or we can defer to have Ms. Monville come in when she's available.
It doesn't seem like a company problem to me. It seemed like an isolated incident.
With some mitigation.
I personally don't see the need to have her come in. I mean, we heard from the other driver what the situation was. I don't think that we need to take an action on it. That's just my recommendation.
Well, I also think that as the Navy saying goes, the shot has gone across the bow, and I believe that Mr. Morrison's going to make sure all of his drivers understand you do not block a lane of traffic. I'll make a motion to dismiss the complaint pertaining to blocking a lane of traffic of the carriage that Miss Jessie Monville was operating.
Do you want to add to your motion the issue about the standing and the horse excrement, or did we already address that?
We haven't, but now I'd like to just put the one issue regarding whether to dismiss the complaint pertaining to blocking a lane of traffic by itself.
Is there a second?
I second it.
All those in favor?
Aye.
Any nays? Motion passes.
Now I'll make a motion to dismiss the complaint regarding having passengers standing in the carriage, and also to dismiss the complaint about horse excrement and failure to have a diaper on the horse.
Second.
All those in favor?
Aye.
Any nays? Motion passes. Next, we have two other complaints. Ms. Mulgrew is not here, but Ms. Doherty is. So I suggest we take Ms. Doherty's complaint up. And I would recommend, since Ms. Mulgrew is not here to present her complaint, that we dismiss that one.
I'll make a motion to dismiss Ms. Mulgrew's complaint.
Second.
All those in favor?
Aye.
Any nays? Motion passes. Ms. Doherty?
The canting uphill.
Hello.
Hello.
Would you like to present your case?
Okay. I am a Lyft driver. When I filed my complaint, I did not work for Sugar Creek Carriages. I have 5 cameras in my car filming at all times. When I was coming off of Korean Veterans, taking a right onto First, there were 3 carriages coming towards me. 2 were on the left. The third one was running her horse up the concrete. When a horse runs on concrete, it is dangerous for several reasons. First and foremost, to the horse and everyone around it. When a horse is running, there is a brief moment where there is only 1 foot on the ground. If that horse slips, it is a huge mess. I've raced standard-bred harness horses for 30 years. I have seen the aftermath of these accidents. It is not pretty.
And you work for Sugar Creek
I do
today?
now. I noted the carriage company for that purpose, because had it been that company, I would not have gone to work for them.
What was the date that this incident occurred?
It occurred approximately 1 week before I filed the complaint, because I had to get it off my dash cam and onto a computer.
So then this was taken when you were still Lyft driving?
Yes. Yes.
So that was?
That was the horse running up the street.
I didn't really see anything, so could you replay it?
So the horse that's running up the street is the one that we just saw on the left there?
On our right, but yes, on the left of the other two horses, passing the horses.
Can we see it again?
And so what you're saying is that it is not standard to
It is
go
dangerous,
more
that is also
quickly
against
up
the
a hill.
ordinance.
Okay. Okay.
All right, so you were driving for Lyft at the time that this was taken?
In my car, yes.
And you told me you thought it was about a week before you
About a
filed the
week.
complaint of March 3rd, 2018. When did you go to work for Sugar Creek?
Not this past weekend, the weekend before was my first weekend.
Which would be
About a week after that.
about a week after filing the complaint?
Yeah, the weekend last weekend was the 17th, the weekend before that was the 10th.
All right.
And so what you're saying is you filed the complaint on the 3rd, and this happened, I guess, the last weekend in February.
Yeah, it happened about a week before that.
And then go to work with them with Sugar Creek a week after the filing the complaint?
Yes.
The 10th? Okay.
All right, Mr. Howley?
I just got a couple. Ma'am, how did, this lady that's showing, so she works for Sugar Creek, is that right? How did Sugar Creek get your film?
Because I had given my thumb drive to the lady
Which lady?
at the office that took the complaint. And they couldn't, and Mr. Fields emailed me that he couldn't open it.
Okay.
So I asked her to help me make a new one.
All right. And you note, when you made the new one, who made it?
I just copied it.
Excuse me, just let me ask her, and then
She put it on a new one.
Somebody, okay.
Yeah, same video.
So, same video.
Same video.
You were responsible for making it, and she was responsible for putting it on film, right, on the screen?
On the flash drive.
Okay. Now, would you run that back, show me the title? What does that say?
It says Southern Comfort Trotting Horse Uphill.
That's what it was.
It was not a trot.
What?
It was not a trot.
I'm sorry, it says trot right there. You
I don't.
set it
I
up.
know what it says, but it says
Well, and then-
the horse was cantering. There's a difference. Everyone
I know
knows.
there's a difference. It says in the.
That is incorrect.
Excuse me, that's incorrect.
The title is
What
incorrect.
else about this is incorrect?
The title is incorrect.
Okay. You understand that the statute or regulation says it can't exceed a trot.
It cannot exceed a trot. That exceeded a trot.
That's all I have.
All right. Thank you.
is there an ordinance that has been,
Under 1254-200, this is titled Conduct of Drivers. Not permit the speed of any horse-drawn carriage is driven to exceed a trot.
Is there a definition of trot in the statute?
There is not a definition in the statute.
Is that like subsection C, D, or something?
It is A14 under 200. But under definitions, there's not a specific definition that would describe the gait or the beat of the horse movement.
Is there, in the equine business, is there a technical definition of trot versus run?
Yeah. It also requires the same thing in 270, not allow the horse. I apologize.
You say 270.
In the equine business, I know that it's not outlined here, but is there anything else that we can refer to that outlines what a trot is?
I can share with general definitions of what a trot might be. A trot is a two-beat gait that has a wide variety of possible speeds, as it describes, but averages about 8 miles an hour. A canter would be the next level up and would be about twice as fast as a trot, as I understand it. We did not provide, we could have brought an equine person in, but since this was not our particular case, we did not bring anyone in to describe the various gaits of the horse when it goes from canter to gallop. And again, you have the range in between starting to how fast. Typically, canters and gallops are not going to be for long periods of time unless it's a racehorse or something like that.
If I may?
Would our inspector be able to observe and tell the difference?
I would not feel comfortable bringing you testimony on my ability of whether it was a trot or I would tell you a trot to a gallop. I'm not sure when you get in between, was it a fast trot or a slow canter, is where I don't feel comfortable doing that.
Do you have anybody that you could refer this to look at and give us an expert
We
opinion?
could certainly send it to the University of Tennessee Agriculture Extension Service, who we have conversations with on a regular basis, and ask them to review it if you like.
If we could do that without the title being on there, I think that'd be a good thing.
And there are probably there are probably professional organizations too that would be able to do
We have
that.
somebody that's not involved in this. Her name is Melody. She runs a carriage.
But didn't you represent her before us before?
I represented her.
All right. I'd rather.
This is my Thursday evening.
Yeah. I thought you had represented her before.
She testified as an expert with regard to the shoes, if you remember. That's the last time. She does not run a carriage. She could run a carriage down here, but she doesn't. She chooses not to. Would you come forward, please?
Well, I don't think that's going to be necessary. I think that it's pretty clear that every company here has an issue with Sugar Creek on some level, and I have a hard time then considering the testimony of even, and I don't doubt her expertise, but if we're going to have somebody tell us the difference between a trot and a canter, we're probably better off going with a truly third-party, independent
I would suggest
examiner.
If you want to go forward with this, we would actually set another date and when we could get a person here who could describe it or at least provide through a conference call or something.
I'm fine with a report or something, that's delivered to you. So.
Okay.
But I'm back to the issue of, is it a driver issue or is it a company issue?
It specifically talks about the driver in one section, and Terry.
200 is conduct of drivers.
270 to 1254, 270, subsection 3 also says the animal pulling a carriage is moved at a speed faster than a trot.
It would be aimed at the driver.
So we're back to the whole thing.
Again, unless it's a company-wide issue.
Yeah.
Do we know who the driver was?
It was Jesse Bonneville.
Again?
The horses are going in for the night. We just had a routine with She's the front horse, and the other two had slowed down to let her get in front. We're on the way back to the lot. Night was over.
Let me ask you a question, Mr. Morrison, real quick. I've rode a few horses, and every time they know they're on the way back to the barn, they take off.
They try to go faster, you have to hold them back, just like horseback riding.
So you're aware this is an issue that could happen when they're on their way back to the barn?
Correct.
Well, that's making it a company issue then.
But like I said, we're aware of that, and we hold them back, but we do need that horse up front to go back into the lot. I don't know why they were going towards our lot, but that's where we're headed. We're finished for the night.
Ms. Monbell still work for you?
Yes.
Mr. Morrison, you saw the video too. I mean, is your testimony that that was not a canter?
It was a trot because they're going uphill. It's hard to canter uphill, but they had slowed down so she could get in front. It looked like a fast trot to me. And occasionally we have a lot of the horses back because they do try to get in a hurry going back at the end of the night. Ma'am?
She leads the other carriages back?
She's supposed to be in the front, and sometimes they're still on a ride when the others are headed back in. When they finish the ride, she comes on, and she was trying to get in front to lead the horses.
I just didn't know if there was a specific reason she has to be in the lead.
You don't necessarily have to be, but depending on what horse you have, some of them like to be a lead horse, others are comfortable following. That one happens to like to be a lead horse.
Given what I've heard here, that Mr. Morrison is aware of this repeated practice or issue, I'd like to make a motion to continue this particular complaint, get an expert opinion from the University of Tennessee Equine Department, and then also ask that Ms. Jessie Monbell be here at the next hearing on this matter.
I'd second that.
All those in favor?
Aye.
Any nays? Motion passes. Thank you.
Thank you.
Ms. Morrison, can you make sure she's here?
Yes, sir.
Thank you.
Can you make sure I'm here? Okay, all right.
We also have a complaint against Music City Touring for failure to maintain liability insurance. Mr. Fields.
In January, Mr. Ross, in January, it was determined that there was not insurance in place for Music City Touring. We sent a letter to the company to advise them that they had to produce insurance, and we asked them to do it the letter was on the 19th. We asked them to, by noon on the 24th, to prove insurance. We had actually gotten a notice from the company of King and Associates that advised us that the insurance had not been renewed and none was enforced. We did not hear from Mr. Ross until recently. At the time we spoke, I asked if he had insurance then. We still have not had insurance brought. He may have it now. We don't have insurance.
How many cars do you have?
We have 4 in total, and at any given time, usually we're operating 2 cars.
So, do you have insurance presently?
We do.
When did you get it?
We got it this week, and I did call Billy Fields. As soon as I got the letter did not arrive in my mail for some reason until early March, and I immediately called Mr. Fields and said I was responding to the letter, and then he said, well, get your insurance ASAP, which we've now done, and we've put significant resources into having the proper levels of insurance.
Did you get notified from your insurance carrier that your coverage had lapsed?
I did not receive the notice at the time as well, but I was also, my lawyer, Kenneth Reddick, will speak to this as well. I was
718 Thompson Lane, Nashville, Tennessee, 37204, is that your address?
Yes. but the intent was to maintain a base level of insurance. The carts were parked as it was inclement weather, and I had to go to the country for a back operation. I did have a general manager and a team in place. One of the gentlemen unfortunately died of a heart attack in January. We now have a new general manager. We have updated our insurance, and I have a personal assistant to make sure that we communicate properly with the commission and our insurance agents.
Did you have any accidents during the time that
No.
you didn't have insurance?
No. And as far as the commission, we've never been brought before the commission for anything else. We've never had any violations of any kind.
Did you say were the cars still operating during that time?
No, we had them parked in a secure facility. Yeah.
So you weren't operating?
No.
Starting when did you?
In December, we had there's inclement weather, and our carts don't have the sides on them, so that combined with myself getting my back attended to, that we parked the carts, and then there was no intent to drive any customers or passengers at that time.
The certified memo, the first page, is that from your office?
Yes. Anytime we have anything of this latitude, that basically the ordinance requires me to bring a company in this particular industry, it says shall be deemed sufficient cause for revocation of the certificate. And so it's brought to your attention. And as I explained that to Mr. Austin, I don't really have a choice. If something like this happens, I have to bring it in front of the commission.
That's what you know that it's up to you. That's it, have it.
Yeah, our intent is always to be in compliant with everything, and that has always been the intent. And we have our insurance documents right here that we can demonstrate that we do have insurance in place.
So you're not operating any of the carts during this
No.
2-month period or so?
No.
And you didn't receive a letter from the insurance carrier or Mr. Field?
I did not receive anything until early March.
Were you going into the office?
Yes. Yeah. The certified letter was sent. One of the addresses on file is on 18th Avenue, and that's where the letter was sent to. But it was in the mailbox in the front. In early March, I went in there and I discovered the letter, but I do have no idea why it didn't get there till March. It was somebody else. There's a little signature from someone. We have a group of offices. There's 8 different entities in our building. So, but our intent was always to maintain a base level of insurance even when they were parked. And we do have other companies that have general liability and this type of thing on that facility.
I think that was Mr. Smith and Bill for. Is that showing where it was forwarded?
Yes, it was that basically is the evidence of where it went and that sort of thing.
It may have, we have 2 different addresses. It may have went to one of them and then it was resent to the other one. We do actually, yeah, we do.
Regularly?
Yeah. And again,
To the correct address.
Again, our intent was to maintain a base level of insurance since the carts weren't operating. We considered that we would not have the commercial auto, the moving vehicle insurance, as we would still have coverage on the vehicles.
So your insurance is canceled December 14th, so you go December 14th to January 14th, January 14th, February 14th, and then into March. 3 months without insurance.
Yeah, at which time...
How much money did you save?
Not a lot.
Well, what's the answer, though?
Like $4,000 or $5,000, maybe.
And that's not a lot?
A month or for the
No,
whole?
in total.
In total, $4,000 or $5,000?
It wasn't, yeah, that wasn't... The intent
And you're
was-
not operating your
No, we're not
carts
operating
because the weather's bad?
Yeah, and
you don't have the cover and
sides
everything?
on the sides, yeah.
You sure you didn't just let your insurance lapse because you weren't operating the vehicles?
No, we honestly, we had them stored, and we believed that the insurance was still in place at a base level.
At a base level?
Yeah, with
I mean, you
general-
knew your insurance had to be renewed in December of last year, right? I mean, you know your policy comes up due.
There's two different aspects to the policy. There's a general liability and then there's.
All right, on this particular part that comes up due December 14th, didn't you know that that lapsed?
Eventually, we did have knowledge of that, and we.
Well, yeah, I know, because
Yeah.
that's why you're here.
Yeah.
But
and-
back in December, didn't you realize, didn't something go off saying, hey, I've got to renew that policy if I want to keep my certificate with this commission?
Again,
If it pleases the commission, Ken read it for Mr. William Ross. Around that time, as Mr. Ross alluded to, he did step out of, his procedure was performed out of the country. And when he mentioned maintaining a base level of insurance, that the person he had that was working for him and with him, that he was kind of under the impression that things were taken. So he was under the impression that general insurance was still ongoing during that time, not the commercial, but he needs general and commercial, and he did have that for the commission right now. So that was, I think, his mistake was not, making sure, but he was out during the time, and he was under the impression that at least that amount had been taken care of, that the general liability. So it wasn't an intent, even though due to the slow season, and he decided to cease, and he wasn't operating his cart. It wasn't because of that. It was just because of the fact that he didn't. I don't think that may not have articulated that, but he was under the impression that at least that minimum level of coverage had been maintained. And we have it for the commission's view that he is fully in compliant and that he is.
If you want, we can give this.
Yeah.
I've worked really hard
8 copies
with Mr. Ross since he became an operator, and I think he'll have to say that on the record. The biggest thing I want to make sure he understands is that the minimal level is what the ordinance says, which is $1 million of combined single limit for each occurrence, as well as liability. So you could, if you had 5, you could reduce it to 1, but you can't reduce it to less than $1 million. And again, the commission knows, and the concern of the people the industry is, I have no desire to keep anybody from doing business, but insurance is something we take, when we find out, there are probably times we don't know. We did know about this, and I would want to make sure that he's clear on what's required and what's not.
And he is, and he takes full responsibility for what occurred, and understand that he has to use due diligence in making sure that he's in compliance.
And it became effective today?
Yes.
You said you didn't get the letter until March, but you did get this email that Billy sent on January 19th that had the same letter?
No, I didn't get an email. And I related that to Billy as soon as I became aware of the letter. I called him the next day, and I also checked my emails, and there was not an email in there. Subsequent to that, the last notice we got came by both email and
You did not receive the email from me in January?
I did not.
But that's the same email address I send to you all the time.
I checked it, and
So you didn't get the one email? Never mind.
Yeah.
When did you get back from Canada? When did you get back from the procedure?
In February.
So you've been gone throughout?
Yeah.
Until February? Okay.
There's nothing in the ordinance that says it's your office's job to remind people of that, right? That's their
It's
sole
clearly on the
purpose.
responsibility
Okay.
company. But we do work. If we know something, we do our best. Our goal is always, in all the industries, our goal is compliance. It's not punishment, discipline, it's keeping people complying and public safety being protected.
Were you, you testified earlier that you were going into the office regularly?
Yes, in the period of time I was away for my back issue, I had 2 gentlemen that were tending to the affairs of the company. One of them, Mr. Robert Norman, passed away from a sudden heart attack in early January.
What is the email address for Music City Touring that Mr. Fields is sending email to?
TWRentertainment@gmail.com.
TWRentertainment@gmail.com. Do you check that?
I do. Now, it's possible that when I was out of the country, it may not have been received properly, because that was at the time when...
You got the March 9th one, right?
Yes, correct. But I didn't get the January one. But that could have been because I was out of the country as well. But at that time, again, I had two gentlemen in place to handle the affairs. Unfortunately, one of them has passed from a heart attack. But right now, we also have another general manager in place, and I have a personal assistant, and I'm getting regular emails whenever Mr. Field sends it.
Does more than one person besides you have access to the twrentertainment@gmail.com address?
Yeah. And again, we've made a significant investment in making sure our insurance is at the proper levels.
Why is the liability insurance coverage only in effect as of today, or I should say yesterday?
Because after my discussion with Mr. Fields, we went back to our carriers and we said we want to get a certain level of coverage. They wanted updated lists of drivers. They wanted different documents in place. They wanted pictures of the carts. They wanted to get renewal information, and my insurance agent did her best to get that to us. And
did you have this level of coverage before it had lapsed?
Yes. That's the same level that we had before. And we do, just as a note, we totally respect the guidelines and rules and the procedures, and we will continue to do so. And we've added more staff to ensure that that will happen, and communication will be maintained with redundancy.
Did you make the payment on this?
Yes.
How much was it?
The total commitment is $20,000.
All right. For a year?
Yeah.
Did you pay the whole commitment?
No, we paid $6,000, or just under $6,000.
So $20,000 for the year. Divide that by 4, it's about $5,000. So that's about what you were saying you saved by not having insurance from December 14th through the middle of March.
The intent was not to save money.
I'm just comparing. I want to make sure I'm comparing apples to apples here. So it was about $5,000 you saved while your carts were not operating during inclement weather.
We desired to maintain a base level of insurance. Was there?
You know, I'm getting more and more frustrated with this language about maintain a base level insurance. You know what was required to be maintained on liability insurance, and you sure knew how to go get it before you came in here today.
And I think it's just going to be a thing.
Baseline insurance wasn't going to keep your certificate for you.
Yeah, I think Mr. Ross understands that it's going to be, a couple of him and someone else shared the same email. So, but he's going to, and I think has worked and put the measures in place to make sure that he doesn't let his insurance lapse. Understands the policy reasons why he has to have insurance, and that there is no reason and any justification for letting insurance lapse. I mean, and he is aware of that, and is going to make sure that that does not happen again.
All right, well, thank you very much.
Okay.
Thank you.
All right, well, Mr. Field, as I understand it, if we find there's been a violation of the ordinance regarding insurance coverage for Music City touring, that we have options of taking no action, probation, suspension, or revoking the certificates.
I think so. I think it's up to revocation is the way I believe you can go.
Someone may have already asked, have there ever been issues before?
I've not had issues other than making sure we were communicating properly.
How long have they had their permits?
Since the beginning of the 2015 or 16.
There's no mechanism to sanction with a monetary penalty?
I'll turn to legal since it's an unusual.
May I see a code section, please?
I assume it's at the end.
How many carts?
We have 4 in total, and we generally operate 2 at any given time.
So you're operating 2 at any given time, so you got 2 in the backup?
Yeah. And our intention is, as we've always done, is to respect the rules and operate in a safe and compliant manner.
How much money do you make off a cart in a month when in this season coming up?
Yeah, there is a big variance between the off-season and the main season.
Starting April 1st, how much do you make on a cart?
We do have to split. We split with the drivers. We would typically make $500 a week to $700.
So Music City Touring makes
something like that.
Your best estimate starting in April, $500 per cart.
Correct.
After you've paid off the driver.
Something like that, yeah.
Okay, thank you. But that's a week too, right?
Yeah,
So
weekly. In some weeks, if rain...
roughly
rain,
2,000.
Rain affects us a lot because we don't have the sides on the carts. But, yeah, generally it's... And then in the winter season, it goes down.
So $2,000 a month per cart, and roughly $4,000 a month is your general operating budget or revenues. Okay.
And the insurance is certainly something that we want to maintain, and we address that.
Well, that was your net, right? The $2,000 a month, not your revenues.
Yeah, that's the net. That's not the gross.
Okay. That's after paying off the driver, and all your expenses and insurance.
There's maintenance, insurance. The engines, like a lot of times, the engines have to be fixed and replaced and that type of things. Because the golf carts, or low-speed vehicles, were intended to be on golf courses rather than roads, so they do take a lot of pounding and abuse.
I wouldn't say that too loud.
Yeah, the potholes are not good.
It's a $50 fine pursuant to section 101.01030, and then it would be a per day fine if he stayed in violation.
So we could fine him $50 a day for every day he was lapsed?
I believe so. Every day, except where otherwise provided, every day any violation of such code or any other ordinance or resolution of the metropolitan government or such rule, regulation, or order shall constitute a separate offense with a maximum of $50 for each separate offense.
Correct. That's fine. I think it's very much like codes or any of the other health department. Any of the metro citations I believe is up to $50 per day per incident or per.
So if we counted the days and it was 100 days, we could fine him $5,000?
I think so.
How about we break this one down into pieces and make a finding first as to whether there's been a violation or not, and then we look at the sanctions if we do find a violation. So,
that's good.
all right, I make a motion that that Music City Touring has violated section 6.73.060.f of the Metropolitan Code for failure to maintain a liability insurance or adequate insurance for having their certificate.
Second.
All those in favor?
Aye.
Motion passes.
I know the chairperson was looking at a possible $5,000 fine, just open for deliberations. I feel that could be a little stiff, but hold on.
And I don't know the number of days. I haven't counted.
Well, I think there are more than 100. You go all the way back to December 14th, all the way to
March 21st.
March 21st, January, February, March. You got at least 30 right there with a short month in February. So, how many? 97, 98? Oh, okay. I stand corrected. It's less than 100.
So, the insurance lapsed on December 14th, is that correct?
Correct.
Well, I thought about, the reason why I started thinking about the monetary penalty is because of your point about there was kind of a savings, maybe that's not the right word, but there was a cost that Music City Touring did not have because the coverage had lapsed. So
unjust benefit, I would call it, yeah, by letting your coverage lapse while you weren't running your vehicles. Then you don't have to say anything more. My perspective on this is that you saved a significant amount of money while your vehicles weren't running. But I didn't mean to cut you off.
Right, and I think that it's an appropriate sanction to be considering only because it is. I mean, we found a violation. I mean, we don't have to find any kind of intent. It could be, I just forgot, I'm so sorry, but it's a violation. And, the penalty can be monetary. Obviously, there was a benefit received by Music City Touring by not having insurance in place for these approximate 100 days. So presumably the money is there. The ability to pay should be there if we were to sanction a monetary penalty. It sends a very good signal to the industry that don't let your insurance lapse because you can get hit with a fine for every day you don't have insurance, up to $50 a day. It's
How many days did you have?
there are other, we can consider suspension. Music City Touring's about to enter into the more profitable season, so that actually might be a worse sanction than a monetary, just cash sanction. I do think that a violation like this deserves more than just a probationary period.
Just so you know, I'm counting 98 days.
98?
Yeah.
Okay.
So we would be prohibited from, the maximum would be $4,900.
I thought it started on December 14th.
No, he got renewed to start on the 20th.
Oh, okay, so she's right, it would be 97. Because you're in.
90, because it's 97, 96. Because the
What-
20th was the last day.
What day was your insurance?
That's about 25.
So he was covered on the
Okay, that's about
23rd.
they divided by 2.
On yesterday, so that would be
Today's the 22nd.
14, 1, 2,
Well, my thought initially was to suspend
97.
Music City Touring down to one golf cart for a month, which would have been about $2,000. But in lieu of that, I'm going to go ahead and just try out a motion. I'm going to make a motion that we fine Music City Touring $25 a day for 97 days for failure to maintain their insurance, which I think comes to $2,425. But my intent would be for a fine of $2,425.
And just so I'm clear, you're recommending 25 because it seems like explain why you're recommending 25. I don't want to put words in your mouth.
Because $5,000 is a lot of money for a guy who's only making $4,000 a month,
And I
and
believe it's up to 50.
it's up to 50, and it's a first-time
Doesn't have
offense.
to be 50.
Correct.
Okay.
Yeah, I think I'm right on that. It does not have to be 50.
It can be, as long as it doesn't exceed 50.
Okay. So let me strike my motion. I'm going to make renew my motion. I would recommend a fine of $25 a day for every day that Music City Touring was not in compliance with the insurance.
And before we get a second, I'm sorry, I just want to get clarification one more time to make sure. So we are allowed to sanction $50 a day as long as the violation exists?
For every day the violation exists.
Okay.
Correct.
All right, and the reasons are just that I think 5,000 is close to 5,000 is a lot of money for a company only making 4,000 a month. But also, I think it needs to be a steep penalty for the reasons that the chairperson has mentioned already, and also I think because I have some doubts about the veracity of some of the statements I've heard today about not receiving emails and communications from Mr. Fields. So I'm a little frustrated about that.
I second.
All those in favor?
Aye.
Aye.
Any nays? Motion passes. Thank you.
I have a question. How, as far as in paying that fine, does he get a chance to continue his operation during the time, or does he have to completely
No, they didn't say that.
Well,
pay the fine before?
There's definitely, Music City Touring has not been suspended or anything. In fact, we did not put Music City Touring on a probationary period, but he will have a certain amount of time to make the payment. And Mr. Fields, if I understand correctly, your client has a right to appeal within 30 days of entry of the minutes.
Okay.
But I'm not sure when the fines actually due. Mr. Fields?
I don't recall that that the Metro Code is going to call a specific time. It's possible, but I'm not familiar with it.
Mr. Ross, can you pay this in 2 weeks?
2 weeks would be a little bit harder to do. Since if we could get a bit more time than that, would be appreciated.
Make sure you tell them the time you need. Don't stretch yourself.
How about we amend our ruling and put a 30-day time frame, and also put Music City Touring on probation for a period of like 180 days?
I'll amend my previous motion to include that, or I will make a second, since that one's already been voted on, maybe make a second motion. I'll go ahead and make a motion that Music City Touring have 30 days from today to pay the previously approved fine and be on probation for 180 days.
Second. So, Counselor, your client will be able to operate during that time frame.
Okay. Thank you.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Thank you. Next, we have a complaint against Nashville Paddle Tavern by Darlene Boston. Fields. There's also a complaint by Sherry Berg.
Miss Boston, make sure, she had called the office today and had said she was going to have a problem getting down here this afternoon and would not be able to be present. Miss Berg, Sherry Berg, I've not heard from Miss Berg.
You want to defer these to next month?
It's entirely up to the commission.
Make motion to defer to the next meeting.
Second.
All those in favor?
Aye.
Motion passes. Next, we have a public hearing. We have two public hearings. The first is we've been asked to review a request by Roadmaster doing business as Cottons and TowPro to transfer and operate emergency wrecker zone that's currently operated by A.B. Collier. So it's, if I understand correctly, Cottons and TowPro are wanting to operate the emergency record zone that's currently operated by A.B. Collier. Is that right?
Correct. Emergency zones are assigned by the commission on an annual basis. You typically at the June meeting in the last few years, if someone wants to operate a zone, they can certainly make application then, or through the year, they may ask to transfer one from one to the other. In this case, they approached the commission, said that they had a business arrangement and would like to Roadmaster would like to ask that the zone operated by A.B. Collier be transferred. Since then, we've also had a second application made by Dad's in West Nashville, with Mr. Mitchell's companies, to ask to have that zone transferred to them. There, Mr. Highland rises off.
Real quickly, this was only a inquiry as to the possibility of a sale. My clients don't want to give up the zone. I represent A.B. Collier. That's all that we're doing here, is to see if Cottons and TOPRO could qualify to take this over. That's just part of the negotiations. We had to do it.
So A.B. Collier is intending to continue to operate the record zone?
Yeah, if they can't get an indication that the proposed purchaser, only proposed, there's no contract signed, would qualify. And they're here. In fact, I represent A.B. Collier. The only reason A.B. Collier's here to say, yeah, if they want to get it, we've had a business arrangement, we can take care of that. But if they don't qualify, then.
Well, the issue, and this comes up from time to time when there's a sale of these companies, is that the zone doesn't necessarily go with the sale.
Most assuredly, that's why they're here. You can't sell something you don't own, and they don't own this. They can sell the company, but they have to have some assurance that they'll qualify. I'm speaking for Dad's and Cottons now, and I don't represent them, but they want to have some assurance that they're going to be able to qualify to do this. And I believe the secondary folks, the folks that have come in, are trying to generate a bidding war now. It looks like that anyway. But both of them are qualified to have zones now, both persons who are interested in it, I believe. So I'll let
It's me.
him do it.
I'm confused.
Good afternoon, Commissioners.
If you'll make sure you tell us who you're with.
Yes, sir.
And everything, it'll
Heading
be
in that
less
general
confusing.
direction. James Weaver with Waller Lanston, here today representing TOPRO. There's no truth to the rumor that Director Fields required me to bring that large picture of a tow truck so that I would remember where I was. Waller Lanston, Lori Beth Westbrook, and I represent Roadmaster doing business as TOPRO. We're here this afternoon to ask that the Commission transfer A.B. Collier's assigned zones 1, 5, and 11 to TOPRO. Our client will come up and present here in a minute and present testimony to the Commission that TOPRO is in the best position to serve the people of Nashville in these zones for 4 different reasons: its qualifications, its equipment, its proposed location inside Zone 1 of the proposed zones to be moved, and the fact that it's the only timely and proper application in front of you today. TOPRO and A.B. Collier have a pending transaction. That transaction obviously is contingent upon what happens in here today. Both parties recognize and understand that the right to operate in these zones is not transferable. It's not an asset that can be purchased by one company. It is only in the preview of this Commission to make the decision to transfer
the right to operate in a particular zone. Obviously, both entities have a lot riding on this decision today, not the least of which is the employees of Collier, which will be all becoming employees of my client if this transfer is approved. We understand that Collier's here and is represented by counsel, and we're happy to take questions. But first, what I would ask Mr. Chairman and members of the commission, if it'd be okay if I could have the client come up and make a short presentation about its qualifications to operate in these zones.
How many zones does TowPro and its affiliated companies work right now?
I'm going to ask the client to come up. Introduce yourself.
Thank you, Commission. I'm David Williams. I'm with TowPro and Cotton's Towing. TowPro currently holds the zone for TowPro, which also does heavy-duty towing for Bailey's company, and also does heavy-duty towing for, what's the other one? Oh, for Carter's Towing up in Jolton. Cotton's has heavy and light-duty towing in Antioch, and that's all that Cotton's purview contains.
How many zones does TowPro and Cotton's have now?
For
zones. The number of zones
The
in
number of zones?
Nashville-Davidson County.
Okay, for heavy-duty towing, Cotton's and TowPro have zones 2, have zones 4, 6, and 14.
How many total zones are there?
14.
And that's for heavy duty only?
That's for heavy-duty. Now, for light-duty towing, they have their respective companies, TowPro's and Cotton's. So just 2 for light-duty towing.
So 2 zones for light duty towing?
Yes, sir.
Which of the zone numbers are those?
I believe that would be 14 and 6.
And you said for heavy duty, it's 2, 4, 6, and 14. Is that correct?
Yes, ma'am.
And A.B. Collier has all of the towing for 1, 5, and 11.
Yeah, all of the heavy-duty towing for 1, 5, and 11, just the light-duty towing for Zone 1.
And I'll ask this of dads when they come up. Do you know which zones they operate?
Sure. Dad's has, for heavy-duty zones, 3, 7, 8, and 13. West Nashville has 9, 10, 12, and 15.
And that's heavy duty, both?
Those would be all heavy-duty. Now, for their light-duty towing, West Nashville has 15, and Dad has 7.
Typically in the office, we do not designate the zones by numbers. The way the assignments are made, the commission makes the assignment for the day-to-day records, as you want to call it. The A class and the D class is what I would call them. D class are the rollbacks, A's are the small trucks. If you get a B class record, somewhere in between the C. The C's that you see, the C's that are operating on the streets are going to be the large ones dealing with tractor-trailer accidents. You may have a rotator, could have a crane even come in to operate on those sort of things. Each company has a backup for the lightweight towing, as well as the C class, which are obviously the larger ones. C class assignments were made prior to me returning in 2012 and have not changed in several years.
Any comments from either the state or Metro on towing response or consolidation?
I spoke with the Emergency Communications Center, which is responsible for dispatching records, and I actually asked if we had any pending problems or any, historic problems in the last several months, and they said they've not had any problems. So I'm assuming that and ask about all of the industry at the same time, just to make sure if it's something else was happening with a company we had not heard about, but no specific complaints. Again, every company, just as we talked about carriages, I can't stand here, neither can, I don't think anyone else, say there's never a complaint. But their substantial complaints or sustainable complaints are relatively rare. We have, I think we have good emergency service, and the companies being talked about today, I think, provide good service for the city.
Now, on the C-Class, how many does A.B. Collier have, do you know?
A.B. Collier has one C-Class wrecker. They make it speed, they've got two. They've got two at the present time, sorry.
So it's two, and one?
Well, they have, I thought you meant wreckers themselves. They, what
Just
they're,
the Cs,
yeah, they have two C-Class wreckers that operate in that zone.
Okay.
And then would serve as backups for others.
Gotcha.
Everybody, there always had to be backups in case of several wrecks at the same time.
So A.B. Collier has two Cs, and then what does Dad's in West Nashville have as far as Cs total combined?
Are you talking about zones or pieces of equipment?
The vehicle.
Equipment? I'm not
Well,
aware.
that's, how many C-Class or the heavies do you have?
Topro and Cottons have a dozen heavy-duty trucks on the road.
Cs?
C-Class trucks, yes, sir.
Okay. And then we'll ask Dad's when they get to.
Mr., you just asked him when he come up.
So you have 10? TowPro has 10 Cs?
We have
Vehicles?
10 or 12 C vehicles, yes.
Yeah, because I think they said AB has 2.
Correct.
Yes.
All right, so you got 10 already.
Yes, sir.
All right. Tell me why it's in the public's best interest for us to transfer these zones to TowPro.
It's in the public's best interest because we're about safety, we're about synergy, we're about collaboration of resources. With the merging of TowPro and A.B. Collier, I believe response times can be quicker, especially with the fleet that we have and the technology that we have as well.
And you said 10 or 12? Which number is it on the heavy duty?
Looks like TowPro has 10 and AB has 2, so they have 12
So they
together.
would go from 10 to 2. Got it. Yeah.
They'll go from
Okay.
10 to 12 together.
Yeah, 10 to 12. Yep. Thanks. Sorry.
All right, thank you very much.
Thank you very much.
Do you have anything else, Mr. Weaver?
That's up to the commission. He has a sort of some prepared remarks, if the commission is interested, simply about the criteria that we understand that the commission uses in order to make these determinations. Not wishing to snatch defeat out of the jaws of victory. Normally, when I get this opportunity, I just sit down and shut up. So I think what I would ask is that you continue with the public hearing. At the end of that public hearing, if there are any questions about our client's ability to handle this, to handle these zones, and we'd be happy to come up and answer those questions. But we'll sit down and just reserve what time you would give us at this point.
All right. And Mr. Fields, I understand that Dad's Towing is here and wanted to speak on this issue. Is that right? And I've got a number of requests to speak applications here, and unfortunately I can't tell if any one of them are from.
Is the owner, the principal of West Nashville and Dad's, and he is present.
Let's hear from Mr. Mitchell first. I've got 3 other forms here, and we'll get to them as soon as Mr. Mitchell's concluded.
I'm Jim Mitchell with West Nashville and Dad's Towing. I appreciate the commission taking their valuable time to hear our concerns here. We believe they'd be valid and very concerning for the future of West Nashville. For many years, we've been the backup for A.B. Collier. At their request, we've done any and everything that needs to be done. I'd like to give you a little history of West Nashville. It is the oldest towing company in Nashville. It's 57 years old. West Nashville has gone way beyond the standard steps of just being a towing company. We have 10 men that are HAZWOPER certified, 40-hour HAZWOPER certified, to be involved in the spill responses. Between the two companies, we operate 16 heavies, 6 of them being rotators. West Nashville increased their inventory and employees drastically to cover A.B. Collier zone and other zones that needed security and needed covering. Some of the zones choose not to do heavy. We understand that completely, and we've covered several of those. Many of these trucks are not paid for and are still being monthly payments on them. We've gone quite a bit further than just a standard towing company on training with many of our employees and allowed training for any of the companies in town to be involved in it. We just completed our 5th Wreckmaster certification training in Nashville. Just to give you a little history of them, of West Nashville, so you can understand a little bit how deeply involved we are. We did recover the jet that crashed from Smyrna, the Blue Angel. We do recover the jets that have damage and injuries at the airport. We have recovered barges that have sunk for the Corps of Engineers. Basically, we've done any and everything that most do not want to do. So we have had to buy the equipment to do it with. Our ability to recover and clean up are way above and beyond the standard company is. We believe that we are in the best position for this, and we've agreed to make the same agreement to Mr. Collier for his assets. And I think that our performance as a zone company will be proven clearly that we have performed diligently to do a good job.
You heard Mr. Highland remark at the beginning that if it gets an indication from the commission that we're not okay with the zone that it has being awarded to TowPro or Cottons, that it's not going to sell its company or give up its zone?
Well, I was under a different understanding than that.
Okay. So is your understanding right now that A.B. Collier's having dual discussions with West Nashville and Dad's Towing and also TowPro and Cottons?
I have had discussions, yes, sir.
And obviously an important part of the sale is to know as a buyer whether you're going to get to operate in the emergency wrecker zone that's currently before A.B. Collier.
Yes, sir. We have been his backup for many years. Our zone is the zone that touches his zone.
Well, we do have a request, and I'm going to rely on my legal counsel here, but we do have an open request from A.B. Collier to transfer their wrecker zone. Is that correct?
Correct.
So we could decide to transfer it to whomever we wanted, to whomever, whatever company we wanted to.
That's how we interpret.
Because I think it's important that
Interpret code section 6.80.545, that there has to be a public hearing before a record zone is transferred, and that from that public hearing, you obtain information as to who is best qualified pursuant to the initial section, service zone section. And then from that information that you obtain through the public hearing, you can decide who should get the zone.
And I'd be less than to do my due diligence. You know, I very seldom disagree with legal, and I'm not completely disagreeing with them. However, I believe there's actually two issues. I think there's an issue of the zone, the transfer. In order to transfer, I think if you're going to remove the zone, I would suggest we have a second hearing to talk about removal of the zone. It was very clear to me when they came in, they did not want to surrender the zone. They simply wanted to enter a business transaction. Now, I'm happy. I think they both know I respect both of these companies. They work very well with me. I am satisfied. Now, again, I can't give you legal advice because I'm not an attorney. I can, from a practical standpoint, I can offer my few years of experience. I think it's two different issues if you choose to transfer it. Beyond the request that was made, again, I have to go back to legal. I can't give you the legal advice. They can. And I'm certainly respectful of them and will respect whatever the commission decides to do.
The application before us is from TowPro and Cottons, right? Is that the only application?
That's part of the issue that's present. Mr. Mitchell did provide Mr. Mitchell and I spoke at the same time this was a beginning. He asked, he wanted to file an application. There's a rule that says that it has to be done 30 days prior to the meeting. And again, that's where that's where I have to go back to the legal advice and what legal describes. I believe that it had to be done by that rule within 30 days, and that's what I shared with Mr. Mitchell. I also, so we accepted an application. We did not accept payment for it. We simply have we haven't done anything with the check. We wanted to, again, come to the commission with what your actions were on this particular issue.
If I could, Mr. Chairman. Again, James Weaver Waller here for TowPro. It is our application to transfer that is pending in front of the commission at the moment, and it's the public hearing for that transfer. I think an easy way to sort of think about this, what you have in front of you is a friendly application to transfer between the Collier folks and the TowPro folks, and a hostile request.
I strongly disagree.
A hostile request, late filed, to say no, don't transfer, don't do what the Colliers people are asking the commission to do, and what the TowPro is asking you to do, but transfer the zone to somebody else. So our application is what's up in front of the commission, and we would ask that application be acted on, and we would ask it to be acted on favorably. The Collier folks are here and be happy to present to the commission that they would like to do a transaction with us. We'll do that transaction in about 30 minutes, but depending on what happens in here. And
that was my understanding too, is that the application was not by A.B. Collier. We didn't do that. TowPro did, and we are here to support that. That's it.
And the application is to transfer Collier to TowPro, the company.
To transfer the current zones that Collier are operating in, to transfer those zones to.
I guess that's where I'm listening to what Mr. Field's saying is, doesn't your application simply talk about transferring A.B. Collier to TowPro, the entity? It doesn't include the zone, the emergency record zones.
No, our agreement, we can't transfer, they can't transfer the right to do that. Only you guys have the authority to do that. We have an agreement, our clients have an agreement with regard to the assets of the company, but that asset doesn't include the right to operate in these zones. That is exclusively and solely your preview, not ours.
And I recognize that. It's just I'm trying to figure out procedurally how this got to us to be reviewing the emergency record zones reallocation from the original part. So, but everything's based on whether we agree to transfer the emergency record zone.
And that's why I asked legal, you know, when we get an application to transfer in a record zone, are we, do we and have a public hearing on it, are we necessarily inclined to consider other requests for this?
According to our review, Mr. Chairman, this exact same scenario has occurred 7 times since 2003, where there's been a pending transaction, but the transaction can't consummate until this this commission decides whether or not they're going to transfer the actual right to operate in the zone or not. And so it's a little bit of a chicken or egg, but this is not an unprecedented situation. This has occurred many, many times in front of this commission. Frankly, to just be brutally honest, all 7 of those times the commission has decided to transfer the license in the friendly scenario as opposed to an unfriendly scenario. But that's obviously the commission's decision today to do that. But that's certainly the precedent. So this is not we went back, the rules are not crystal clear about how to do this. And so what we did is we went back and looked at tapes, at a lot of tapes, and figured out how past commissions have done this. And that's the procedure that we're following today.
Mr. Fields, when the office received the application to transfer the record zone service that Eddie Collier's operating, what type of notice goes out to the public?
If you'll recall, at the last meeting, we actually announced it at the February meeting. There is no specific requirement other than we provide public notice. We placed it on the website on March the 9th.
And then we heard from Dad's towing shortly there.
Well, in that time period, I couldn't tell you exactly when because I didn't record my phone call, but Mr. Mitchell and I did speak. He has expressed since I came back he would like to operate, and he's not the only one. He would like to operate all the record zones, but I think that's true of several of the companies. So he's certainly interested in transfer.
Well, playing the tape out, if we don't transfer the emergency record services, then AB wants to hang on to theirs.
Yes, sir.
So unless we were to take some extraordinary action of taking them away from AB and giving them to West Nashville or Dad's, it would all stay the way it is unless we grant this transfer.
Exactly. Yes, sir.
I don't know if that made sense, but what I'm trying to do is figure out if we were to say no to the transfer being requested here, and Mr. Mitchell, you might not have anything anyway.
Well, I'm not here to damage Mr. Dunn from making his sale. I know he's interested in selling. My objective is to make it as smooth as possible, and I'm not the unfriendly by any means. I'm friends with both of them, actually, to be honest with you. But
you're expressing your interest.
I'm expressing my interest.
I'd like to have a shot at it.
And my concern, because we have been the backup, and we have been covering the heavy part of it. We actually bought extra trucks, extra equipment, extra employees to do this job, and we've been doing it successfully without a complaint. I believe you'll hear plenty of other recommendations in the next few minutes about the type of job we have done. And I don't believe that there is any company actually in Tennessee or probably the United States that can compete with West Nashville.
Chair, if I could just read section 6.80545D, which is what I was referring to earlier, if you have it available. It's transfer or zone assignments. Section 1 says no licensee designated by the commission to provide emergency record service within an assigned emergency record service zone shall sell, assign, mortgage, bequeath, or otherwise transfer the right to service such assigned zone without commission approval following a public hearing as required by section D2, and then you drop down to D2. Prior to the transfer of any zone assignment, the commission shall hold a public hearing for the request. The commission shall establish the date and time, and it talks about application fees. So the reason why you have two different types of transactions, depending on which way you see it. If you look at Rule 12, that speaks to the application or transfer of a certificate. And Commissioner McNally is correct that if you transfer the certificate is really no good without the zone. However, we have a different code section that governs the transfer of the zone. So the two sections that we have that don't speak together. That's why we have a conflict. The way that Billy noticed it was according to Rule 12, which is how you notice an application for a transfer of certificate. It's you give the 30-day notice, and that's just assuming that you're just transferring a certificate. Like if you had a taxi, that you're transferring a certificate. You're not transferring a piece of business that affects other operators, like in this circumstance. If that makes any sense.
Yeah, and you're not transferring You may transfer the certificate to operate, but not necessarily saying they can operate downtown or
Correct.
at Centennial like we do the carriages once in a while.
Right, so then you have Rule 12 that speaks
Yeah.
specifically to how you transfer a certificate, but then you have the section of the code that speaks to how you have to have a public hearing for the zone.
For the zone.
So they don't necessarily go together.
But we're okay today to make a decision if we wanted to transfer them, because we're having a public hearing.
Right. So we're a little concerned that the notice in the agenda does actually speak to a transfer of the emergency record zone,
Yeah.
but it speaks specifically to the transaction between Roadmaster and A.B. Collier. It doesn't kind of throw it open and say it's an emergency zone hearing so that anyone other than dads, although dads obviously did figure it out and apply. I wonder if there might have been other contenders who might have also thrown their hat in the ring if it had been noticed a little differently. So I do see a little bit of an agenda notice issue with that.
If we open it up.
If you open
Broader
it up.
than
So it
just
might be
the-
wiser or more prudent if you decided to open it up to go ahead and defer it one to one.
Mr. Mitchell, I do have a question. I understand your financial interest and you've been backing up A.B. Collier, but can you state any harm to the public if we were to grant this transfer of the businesses and the zones from A.B. Collier to Roadmaster, TowPro, Cotton, whatever their name is? I mean, can you say any harm that would occur to the public if we were to grant this transfer?
I can't say that there's any harm that would come to the public, sir. I don't believe that, and I'm putting anybody down any means whatsoever. I don't believe that there is a tow company that's close to the qualifications of West Nashville anywhere, because we've gone way above and beyond the call of duty to be prepared for not just the accidents, but for the chemical responses. And you'll hear that in the next few minutes of how we've done and what we've done to do that. No one else has gone the extra mile that we have to do this.
Thank you, sir.
Yes, sir.
Well, let's go ahead and hear from the other three folks that have asked to speak. Christopher Graham.
Hello, I'm Chris Graham. I operate Chapman's Record Service Zone 5. The only thing I wanted to speak on today is I've operated that zone with my father for, I think, close to 15 years now. Since Cotton's has taken over, I've had a few issues in the past, and I try to call David. I try not to go to the board and mess with anybody. I do the same with other companies and try to take care of it outside of bringing it up to somebody. And it tends to work most of the time. I have a problem with out like 24 all the way out towards Harding. Their drivers have a tendency to want to stop and ask the police department, is it possible for them to go ahead and move it out of the road? Or I've had it happen here recently. And it's really, I lose probably, if I had to put a number, 10 to 15 calls a week out there. Part of it is kind of the way the zoning through the Metro themselves have done it. I don't know if it's how it gets called in, but that doesn't, when their drivers stop, you're not supposed to stop. That's soliciting at that point. You can't, even if it's, you can stop, pull over, and ask them, because our duty is to get the road clear. Now, if I stop and say, can I move it out of the road so you can get the road back open, that's fine, go on. But you can't try to hustle the business, especially out of somebody else's. That's the only, that's the biggest issue that I have. If they take over A.B. Collier, it's adding them to another side of my zone. So it's giving them somewhere else to pull from. I personally, I would rather not see it happen. I don't have a problem with A.B. Collier. We've had some issues in the past, and we've resolved them, and to my knowledge, we all get along. But I feel like if they take over, it's just giving them more room to pull from me and steal from me.
All right. Thank you, Mr. Graham.
Thank you.
Kenneth Carruthers.
Good afternoon. My name's Kenneth Carruthers. I'm the owner of Mike and Safety Group, located here in Middle Tennessee. Was approached by West Nashville Wrecker in 2015 to take over their training program for hazardous materials recovery, response, and mitigation. During that time, they've assessed 10 employees that have exceeded the standard training per OSHA to work on the scene of a hazardous materials incident, whether that be in Davidson County or surrounding counties as well. Some of the things that I don't know if the board's aware of, that OSHA mandates the requirements or the training levels for all hazardous waste operations and emergency responses. They have exceeded those, and being in the emergency response business, it's clear that they meet not only the minimum standard, but the 40-hour training that is required. As far as Mr. Mitchell's concerns to the board of them being the best in the business, as far as being in Middle Tennessee, I would have to agree with the initiation that he took to put his company above and beyond what is a normal standard. Thank you.
Thank you, Mr. Carruthers. Also, we have a request from Emerson Boguski.
I'd like to thank the Commission for this opportunity to speak just a few minutes. My name is Emerson Boguski, and I work for the State Department of Transportation out of the Office of Highway Incident Management. I work primarily out of the Nashville Help Unit, which are the yellow trucks you may be familiar with on the highways. I need to be real clear here. I am not here to speak officially on behalf of the state of Tennessee. I do not have that authority. But in my role to speak, my primary duties are to get these interstates open as quickly as I can, as safely as I can, manage the recovery operations, and all related matters, the chemical spills, safety, everything that goes with it. Before coming to TDOT, I had the privilege to work for the Nashville Police Department for 33 years. I spent 28 years of those as a fatal crash, major crash investigator. And with the opportunities I had there and the opportunities I've had at TDOT, I have had the privilege to work with each and every one of these people that are here to conduct business today. I know them personally, I know them professionally, but I'm not here to speak on any personal matters. I've been before this board many times for many different reasons. There have been times when I was here either pro or con, but that is not today. My reason for being here today is safety. One of you gentlemen, I believe asked Mr. Mitchell, could any harm come? Could any harm come? Harm can come to us anytime, anyway, at any place. The key to safety, to reducing harm, reducing death, injury, is quick clearance. We have strict mandates or requests at the state to clear these things as quickly as we can. And one of our big concerns, basically, is getting the roads open to prevent the backups, because 28% of all fatal crashes come from backups and unnecessary closures. The current system that's in place now, again, going back to my time where I worked at the other place and today, I've seen many changes come through this board. Some of them good, some of them bad. But I think for the first time in a long time, we are so fortunate here in this town. We need every big wrecker service that's operating in this town. There's that much activity on the roadways. The need is that great. These companies, they all do great work, and they work hard. But it's getting so noticeable now, whether it's Mr. Mitchell with Dad's or Mr. Dunn with Collier, sometimes they actually may have 2 or 3 of these big things going on because so many other counties outside of Davidson County rely on their services, their abilities, their equipment. So there's so much more that goes into it. Who's got the most trucks, who's got the biggest trucks, who's got the prettiest trucks, okay? The knowledge and the skills. Sir, I can go out here and they'll let me. I can drive any wrecker they got, okay? That does not make me a wrecker person. It takes a true operator, okay? So when you get into training issues, the hazmat situations, they've all learned so much through their years of experience, but there's so many other factors that have to come into play that I would just ask the board to please consider all factors involved and do what y'all think is fair and right. I will say this, for the first time that I can remember in a pretty good while, the current setup now seems to be more fair and equitable and equally divided among companies, that everybody that's a stakeholder got a place, okay? And we are pleased. I am pleased as a professional, okay, in doing my job. I feel like the state of Tennessee is pleased, okay? But again, please don't, I'm not speaking on behalf of the state. I'm just here to offer opinions as somebody who works in this field, and hey, when I'm off, I don't like to get stuck in traffic jams either, okay? So I'm here as a private citizen as well as someone. I have a personal and a professional interest. Personal from the standpoint, I don't like to be held up. Please keep that in mind. And professional, because that's my job, to work with all these people that I've known, know their qualifications, know what they can do, and see, I think we're at a good place where we need to be right now. And I hope that they continue their good works, and I would ask you to just consider some things that you might not ordinarily see or be familiar with when it comes to this type of work. Thank you.
Thank you, Mr. Boguski. Is there anyone else in the audience who wanted to speak on this matter? Before we close the public hearing, would A.B. Collier or TowPro or Dads like to add anything before we close the hearing?
Just one correction. A.B. Collier has been in business in the Nashville area for 88 years. It's not, Mr. Mitchell said he was the oldest. Well, that doesn't make a lot of difference except 19 years.
The only thing that I would just add after listening to the public hearing to this point is that what we're talking about here is towing service, not hazmat services. I understand from the Collier people that it's been 5 years since they had a hazmat call in their zones. Obviously, hazmat calls are extraordinarily important, just perhaps not particularly relevant to the decision that's in front of the commission today. We're happy to come up and give you a full and complete explanation of TowPro's hazmat program, but it's not really part of the criteria here today, and so that's why we've left that out. It's not that we don't have it, it's just not exactly relevant. Thank you, Mr. Chairman.
Right. Mr. Mitchell?
Thank you again. I think that Mr. Boguski made it very clear that it is good as the way it is now. It's operating properly. It's operating good. The way that zones are separated and spanned out is pretty equal. I disagree with
to be a timing issue in terms of response time if TowPro begins operating in the A.B. Collier zone? Is that the point that Mr. Boguski was making?
I'm sorry, sir.
Do you see that there's a response time difference between when A.B. Collier and, from time to time you say you back up A.B. Collier in their zone? Is there a response time difference between now and what would occur if TowPro and Cotton's operated that zone?
I have a zone map. I know that quite often we don't get to see the zone map, but I have a zone map that shows you this green here is West Nashville, and the yellow here is A.B. Collier. You can see how we border it right here, and then you can see Cotton's is over here, and TowPro is over here. So it's a big difference in the distance between us. We are bordering them all the side here. The other company that borders them, of course, is Chapman's right here. and Mike's Custom Towing. And then over on this side, Hillwood. Do you want me to get that closer?
That Forest Hills?
All right.
That's Forest Hill, Oak Hill.
This is West Nashville. So that's one of the reasons it's been convenient for us to maintain that. I mean, one of the reasons it's worthwhile for us to, extend our fleet to be able to do that.
Ryan, I didn't mean to interrupt you, so.
That's okay. As far as spill response, pretty much every accident that happens, there is the need for cleanup. I don't think I've been on one that there wasn't some form of cleanup to be done. An oil pan busted on a big truck, a fuel tank busted. The last few that we've done have been battery acid. Battery acids that you think of as a little battery, I'm talking hundreds of gallons of battery acid that you can't get close to within 50, 75 yards of them without strangling. So this is a big part of what's transported all the time in our city now, and it has become a big part of being able to fulfill the duties. Some of the companies rely on other companies to come in and do this, and response times are very poor on them. Our company is qualified with the response to be able to do it immediately. So it is a lot more important than was led on to be. And I think in the future, from we see traveling through Nashville, if you knew what every one of the placards meant on the back of every truck, you might not follow that truck. It's pretty surprising what goes through here. Thank you.
Mr. Chairman, for the last time I will come to this microphone. But you asked a question about response times, and I think it's important to address that if my client is allowed to do the transaction with Collier, then we take over Collier's locations actually inside these zones. So Mr. Mitchell's talking about operating these zones from outside because he's not going to be able to acquire Collier's stuff because they don't want to sell it to him. So what we're talking about with the transfer, there's not going to be an issue with some sort of increase in response times. In fact, we believe the response times will get better with TowPro's equipment and dispatching and things like that. But so there's no issue about if this transfer is approved by this commission. We're not going to see a deterioration in response times. In fact, we expect to see response times increase. It is extraordinarily important, as the gentleman from TDOT pointed out. But we're talking about acquiring their company, their location, their physical location inside these zones, and we'll be dispatching from there. So there is not a concern as it concerns response times. Great question, and again, I am so sorry for having to come back up here. Thank you, sir.
Thank you.
Chair, if I could just give you one more bit of guidance.
Yes.
Going back to section 6.80545 is service zones. I just want to read that so you can understand or glean at least what you should be looking for. In order to provide for the immediate removal of those vehicles, interrupting the proper and orderly flow of traffic and thereby constituting an emergency situation as declared in a different subsection, the Commission is authorized and directed to divide the geographical jurisdictional territory of the metropolitan government into zones for emergency wrecker service, which zones shall be established in a manner which best serves the traffic and safety needs of the community and as near as possible divides the emergency wrecker business equitably among those persons licensed to provide emergency wrecker service. Here's the section if you guys, well, disregard my note.
Mr. Mitchell. Excuse me again. Of course, our intent, the last time I spoke with Mr. Dunn, was to do the exact same, except the same location and all, too. The only way I could have derived it, the amounts, which I had to go to my bank with, was to discuss it with him and go over what amount it would take to do this. And from the time I initially found out it was available to the time I got back with Billy was a transition period of going through to make sure I could approve for the financing on it. I mean, it's not a small deal, so it's not something that you just have ready available to do. In the past, I wish we could pull up some of the filming of operations of hazmat being done in Nashville and how severe it was. If you talk with Mr. Carruthers again, you might be able to understand the importance of it and the operating of the improper operating of a spill response situation. And as I say again, I emphasize that nearly every accident there is something that has to be cleaned up. And as you watch the greens travel through Nashville, it is more and more and more important about the amounts have gotten less and less that you have to report. The proper disposal of it, we're directly connected with the correct company for the disposal of everything properly. And I think that there's no other that's capable of doing it quite like we are. Thank you.
My name is David Dunn, and I own A.B. Collier. And I'm going to tell you like it's in a nutshell. I promised TowPro 7 or 8 years ago if I ever sold A.B. Collier, I'd call him. I called him. He wanted to buy it. Jim Mitchell called me, wanted to buy it. I kept my word. And I don't understand why he can come up here and tell you that he's my backup and try to use it against me when all I'm doing is what y'all told me to do. If you can't go in a certain time, use your backup. I'm using it, but now I feel like I'm being penalized. But I want you to know about A.B. Collier. It's not just a regular record company. A.B. Collier was in business before you ever had to have a driver's license. It was in business before the Grand Ole Opry was ever invented. It was a big barn dance. It was in business before Crystal ever come here. It was in business before there was ever a lake in Metro or Davidson County. We've been operating for 88 years with an despicable record. And it just tears me up to see it like a piece of meat. You know, I got the deal with TowPro, not him. I kept my word with him. Now, I'm sure Jim Mitchell, he said he would pay me if you would give it to him. But is that how business is supposed to work? But he can't pay me because I'm not going to sell it. If y'all don't okay it to him, I'll keep it the rest of my life.
Thank you, Mr. Dunn.
Well, I apologize if I upset Mr. Dunn. That's such a different side I've never seen before, and my intentions were not to upset anybody in any way. I thought that we were on the same page on this, and this sort of flip-flopped from the last time I was here, and my intentions were not to cause any grief with it. I thought the same deal would be the same deal either way, so there's obviously something I'm not aware of or something I don't know about. But again, I apologize for upsetting Mr. Dunn. I didn't have any intention of doing that.
At this point,
Can I ask Mr. Dunn one question?
yes.
Mr. Dunn, can I ask you a question?
Sure.
I think it's obvious you want to sell to TowPro to keep your word. Why do you want to get out of the business?
I want to retire.
Okay.
I've been licensed in Metro for 44 years in the record service, and I'm sick of it. But I will keep it and do it the rest of my life.
Thank you, sir.
At this point, we'll close the public hearing. So we have before us a request by Roadmaster to have transferred to it and operate the emergency record zone service is currently operated by A.B. Collier. Proper notice was given of that request last month that we were going to conduct a public hearing today regarding that request. In the interim, Dad's Towing and West Nashville Towing requested to be heard because it wanted an opportunity to operate that record zone service as well. And we've conducted our public hearing and sought guidance from our legal counsel, and have been notified on what are the proper grounds for awarding a service zone or transferring a service zone to a new provider. And under section 6.80.545, it provides that zones shall be established in a manner which best serves the traffic and safety needs of the community and as near as possible divides the emergency record business equitably among those persons licensed to provide emergency record service. So that's our guidance. We've heard from Mr. Weaver. He said that if the transaction between Roadmaster and A.B. Collier were to go through, that Roadmaster would operate from A.B. Collier's facilities in the zone, which obviously is relevant to the issue of being able to serve the traffic and safety needs of the community and be as near as possible to those instances. The secondary consideration of trying to divide the zones equitably among the licensed emergency providers, that, to me, and I'm just speaking for myself, but I'm trying to summarize and give my thoughts as well, since I don't get to make a motion. But it seems to me that both DADS, West Nashville, and Cotton's TowPro operate significantly in the county and handle a number of heavy-duty zone operations as well as light-duty zone operations. So whether we decide to grant the transfer request to Roadmaster or not, it seems to me that that consideration of trying to divide the zone service equitably is not as impactful. So then it really just falls to trying to decide if Roadmaster can serve the zone well and meet the traffic and safety needs of the community. I mean, I'm inclined to grant the request because they have followed the procedures that have been laid out before them as best they can. And we've had an opportunity to hear from DADS in West Nashville. I understand that they're concerned economically how it might impact their company because they have grown accustomed to backing up A.B. Collier. But that issue, unfortunately, in and of itself, is not, in my mind, as relevant as determining which company is best to serve the traffic and safety needs of the community. And if we don't grant the request, Mr. Dunn has stated he's not going to sell to anyone. He's just going to continue to operate the company. So again, I get back to my inclination is that we grant the request to transfer and operate the record zone to Roadmaster.
A quick question. DADS and West Nashville are the same, is that right, Billy? Same company? It's okay. So that would put them at 8 zones, if I'm doing this correctly. And if we grant the request, it would put AB TowPro at 7.
That's the way I calculated it. Yep.
That's what I have to.
I don't know how equitable that is among all the other ones that may have licenses to do emergency wrecker business, but between these two companies, it's a fairly
essentially
even divide.
If you went either way in this, you're going to end up with 2 entities doing heavy wreckers in Nashville, which I think would probably mean we really need to look at how it is backed up to start with, because again, that's what's there. This doesn't preclude any of the companies that already have certificates or licenses to be an emergency that operate a emergency record zone, they could all operate C-class. A C-class record, if you look at the largest of the C-class records, the cost of those records, and we can argue $1 or $2, but they're going to start around $1 million. I mean, you're talking a lot. I mean, you're talking hundreds of thousands of dollars rather than thousands of dollars. A rollback record is going to cost $150,000. Rollback. 100. I mean, that's just the little ones that come. So I mean, it's an expensive proposition. I think again we are well served. I would comment on Mr. Boguski's comment. He certainly has paid the dues over the years. He is right. We have a good service in Nashville, and they're very competitive, and I certainly recognize that.
But as it is right now, most of the emergency wrecker zones are held by Roadmaster or Tow Pro, A.B. Collier, Dad's, and West Nashville.
Well, actually, Tow Pro and Cotton's operate two separate zones.
Okay.
West Nashville operates a zone, and Dad's operates a zone. You go to Martin's, Bailey's, and Mike's Custom are all owned by the same person, operated that way. What they're talking about is two separate things. You got the issue of wrecker service versus heavy-duty wrecker service.
I'm looking at the heavy-duty.
Oh, okay.
You really got 4 companies that have the lock on the heavy-duty.
Well, the 5 companies that are currently have C-class wreckers are the the 3 entities that are here today.
Dad's, West Nashville.
Cotton's Tow Pro, A.B. Cotton.
Cotton, Tow Pro, yeah. I didn't hear anything that said that traffic or safety needs would be impacted by this transfer in a negative way. I asked Mr. Mitchell specifically, and he couldn't say that it was going to impact it negatively. And what we're doing is just reapportioning it to where Dad's in West Nashville has 8, and Tow Pro Cotton would then have 7. So, I make a motion to approve the request by Roadmaster to transfer the emergency record zones currently operated by A.B. Collier.
Second.
All those in favor?
Aye.
Aye.
Any nays? Motion passes. Thank you.
Mr. Chairman, I'd be remiss if I didn't make a comment. The courthouse security typically closes down at 5 o'clock. We're at 4:30. There have been people who've waited a long time for a public hearing regarding the KCI technology slow-moving vehicle study, which relates to pedal vehicles and low-speed vehicles. Unfortunately, I don't think the commission's going to have enough time to actually go through the process, have the public hearing, and be able to be out of the courthouse at an appropriate time. It may be 1 or 2 things we would need to do, I think. Either call a special meeting or to defer action till the April meeting. And clearly it's your time, and I appreciate and I'm certainly hate for the people that have been here, but it's an issue that it's important for a lot of reasons, and I would hate to cut it short. The fact that y'all have been here now for several hours.
Will we be able to have it at the top of the agenda for April, or do we have to follow?
No, basically what we try to do is set it so we can move through the agenda in an orderly fashion. Unfortunately, I knew today was going to be a challenging day because of the things that just showed on the agenda. Present time, the only thing you have scheduled for you have another public hearing you asked to have in April, and that would be for the horse and carriages. You're not precluded from moving the horse and carriages to May and moving this public hearing to the April meeting and doing it at the beginning of the agenda if that's what you choose to do.
What date is the April hearing?
26.
April 26th, I'm advised.
So what's on my calendar?
Well, I agree. I think that given that it's just after 4:30, that it would be very difficult to give this hearing its full due today. And I apologize to all the people in attendance who were expecting to have the hearing today, because I know how time-consuming our meeting today has been. So, I mean, I certainly don't have a problem putting it to the 26th. I would think that we should probably move the horse carriage meeting, or hearing, rather.
It's your direction. And we can place this at the very beginning of the agenda.
Do we need to make a motion on that?
Since you scheduled a public hearing, it may be appropriate to reschedule that public hearing.
Make a motion to review the KCI Technology Slow-Moving Vehicle Traffic Study to the April 26th meeting and offer our apologies to everybody who's waited so long.
Second that.
All those in favor?
Aye.
Motion passes.
Make a motion about moving the horse carriage as well.
Make a motion to move the horse carriage meeting, public hearing to the May meeting.
Second that.
That wasn't on the record.
Second that.
Okay.
All those in favor?
Aye.
Aye.
Motion passes.
And just, I apologize, I jumped in too quick. You were going to ask about other business.
No.
In other business, you want to make sure we did announce earlier the intention to discuss the transfer of a certificate of public convenience and necessity from Nashville Taxi Ride LLC doing business as Checker Cab to American Rivergate Company.
Thank you, Mr. Fields. Is there a motion to adjourn?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes.
Thank you, sir.
Good job, Sal. You're our hero.
Oh, yeah, we actually do need that.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.